Talking about what? What? On me, man. Nope, not today. Not today. Not today. Nope. Not today. Not today. Nope. Yeah, you hear the bells. You hear the bells. It's Christmas time. You hear the bells. It's Christmas time. The bell. Yeah, hit the bell on them. Whoa, 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 whoa. We're going to let a couple people tap in. I had a problem with the last stream. Messed up on you, boy. Get y'all to tap in with me. Let's see. Where we coming in at. Before we get started, too, I want to let y'all know that tonight we have another stream going to be happening. It's a community stream, though. It's through what we call our Operation Wise Dome. We get together about 2 to 3 hours. I think last one went for 4 hours, or the first one. It's going to be the second one. It's going to be tonight at 6 p.m. Pacific Standard Time. Yep. And we get together and we're going to be talking about a lot of different things. But I think tonight we might go through some probable cause stuff, some rule of lenity, bring some people up that may need to go through and get some help done on some things as far as understanding some things that we can pull through ChatGPT or development, whether it be questioning or any kind of motions as far as templates are concerned, deeper on their aspect. One thing I want to let y'all know just while I'm here real quick before we start is that if you want, we got the community is paying, our community is paying for ChatGPT, like the full O1 model, the pro mode too. And it's $200 a month, y'all. And so if y'all have anything that y'all want to like work on with that, because we got unlimited use for like anything you need help on to utilize the ChatGPT in our prompts, you just let us know. You come through on the Operation Wisdom, and that's what we're trying to do. We're just trying to freely allow the AI to help us now, right? Because I think the problem that we had was just aspects of learning how to develop these things, not cross-referencing, looking through Google Scholar or going through a Pacer system or going through courtlistener.org and just looking at what's being filed. And once we see what's being filed, granted, denied, proposed orders, motions of all types, you really start to see like, okay, well, I can operate the same way too. And I can pull these documents from these sources and feed them into ChatGPT and develop what we need to develop in that same type of manner and then understand it, right? So like right now I have a lot going on because I got my first civil suit against the city. I'm about to file 2 more actually. But with that being said, like there's a lot of learning that goes with it, and each step that I don't understand, I'm pulling right out of ChatGPT to say, hey, give it to me in advanced aspects on things that I can file, and then also give it to me on a basic dummy down form so I know what to do. So I'm staying on point. I got a legal assistant at my fingertips at all times, and the community has come together so you can as well. And so that's why we have Operation Wisdom. It's pretty cool, y'all. It's pretty cool. So if y'all want to show up tonight, that's going to be you should see the link in the description. If not, you can find it somewhere. Maybe I'll post it right now. Let me see if I can find that bad boy. Let me find it real quick, huh? Oh no, it's probably in the description. I don't know. Let me see. It's right here. I got it. So copy and then paste. Boom. But what I want to get into, we getting right back into the most sacred liberties, y'all. The most sacred liberties is so important because it is a very, very, very deep and detailed document that we've been going through. This is part 11 of this series. Again, I just want to thank y'all for being here. I don't want to be too much long talk, so let's get right into this thing. So where we left off was, where was we, boy? We was up here. As one may well established by the length of this reading that driving is and must be of a commercial nature. Commercial nature. Driving, commercial nature. The term commercial means to engage in commerce, to produce, to deliver, and receive payment is commercial, as being in commerce. Everything from trucking coast to coast to the variety of local fast food joint where they produce a cheeseburger, deliver it to the counter, whereupon credit is transferred to the store. Man, I hope I'm not. No, this is the right spot. Okay, cool. Wait. I want to just check. Driver and public transportation. I think we did read that, Wallace and Bliss. Man, you know what? I hope I'm not. Okay. I hope I'm not skipping some. I'm just wanting to be, I don't want to skip nothing in here. And I'm hoping in my parts that I found out exactly where I was from part 10 and now translating onto part 11 just fine. I could have swore I saw the plumber. So we're just going to have to roll with it, man. All right. So the plumber may be the best example here of operating and driving and commerce and private carrier under 16,000 pounds. The plumber, um, the plumber, the very substance epitomizes the very substance of these definitions. Title 81 RCW is the best definition of a plumber. RCW 81.80.0106. A quote, private carrier. Private carrier is a person who transports transports by his or her own motor vehicle. That's again another commercial term right there. Motor vehicle. This thing's full of commercial terms, definitions. With or without compensation. With or without compensation. Property which is owned or is being bought or sold by the person or property where the person is the seller, purchaser, leasee, or bailee, and the transportation is incidental to and in furtherance of some other primary business conducted by the person in good faith. In good faith. Oh, I need to make sure to turn my live chat on this one. Y'all can hear me on this one, huh? Last time they said couldn't hear me, I messed up. Let me do one more thing. Yep, let me try that. Okay. In good faith. Wait, in furtherance of some other primary business conducted by the person in good faith. Let's rewrite the statute definition for the purpose of this writing. A plumber is a person who transports by his company truck, van, with or without compensation, your new shower stall, which is owned or is being bought or sold by the consumer, client, or property where the plumber is the seller, purchaser, leasee, or bailee, and the transportation is incidental after being picked up at the warehouse to and in furtherance of working on your bathroom conducted by the person in good faith that you will pay him for his services. You see how like much business has to be in alignment here, right? Commerce is a big deal. It's not a joke. Like there has to be so many things. Okay. So now let's excerpt that definition. A plumber is a person who transports by his company truck van your new shower stall, which is bought by the consumer client, or the plumber is bailee of your new shower stall, too, and in furtherance of working on your bathroom. Remember, no driver's license is needed. Let me turn this up a little bit. Operation is needed to operate a business. Conversely, no operator license is required to drive. When the state of Washington defined driver and operator to be the same thing, it in fact was intended to reify these two separate functions in order to bridge or bootstrap common law traveling. To bootstrap common law traveling. What's going on there? Because then most common people that have the driver slash operator license fit quite neatly into this perverse extrapolation. Licensing. Uh-oh. We getting into it now. What's up, Irish folk? What's up, Irish folk? What's up, Mitch Lovin? What's up? And then what's up, Austin? What y'all got going on, man? What's going on, y'all? Okay. Licensing. We're getting into it now. Let's see what we got. Okay. So a claim may be laid that RCW 46.20 is void for vagueness as being overbroad. Similarly, void for want of due process. Similarly, facially void and as applied void. Now, why is that? Let's take a moment to really think about that. Why is that? I want to just see if we can have a little conversation on this to why that might be. Okay. So if we have The claim may be laid that RCW 46.20 is void for vagueness as being overbroad. Overbroad in what aspect? Well, I guess what we would have to do is we would have to check out 46.20. Or is it laid down here before us? Maybe further down. Maybe it is. Okay, so we get into it. But the aspect here that I'm thinking right off the bat is void for vagueness, overly broad. The same aspect in which Luis is currently going through. If a statute is not narrow, if it does not specify, if the legislature has not put into place with specificity, notice has not been given, therefore breaching due process, therefore in void and want of due process, both facially and as it can be applied by the prosecution. Do you see the principles and how they can be applied rather than just, again, looking at the charge itself? We get into the deeper principles of looking at the statute and does it fit within how they are applying it through the prosecution, whether it's broad or whether the statute is vague, like we just went through this morning in a video that was released. So it's very important to look at these chess moves before even bringing out the queen. You know, there's lots of things that can jump. You know what I'm saying? Or go ahead, get out there, man. You know what I'm talking about? So let's see. Boom. If I go back to my share screen, entire screen, boom, share. Oh, it always does that though. Okay. Now, this can be articulated by demanding the state to provide the section of the act that provides substantive notice of its application to personal use of personal automobiles. Exactly my point. If we're looking into the statutes and we're looking into the historic aspects of the statutes, which again we have to invoke that whole act rule, right? If we look into it, we can see it's always been commercial. So if it's not explicitly stated in the statute, it is overly broad. Demanding that the state provide a section of the act that provides substantive notice. Same, by demanding that the state to provide the section of the act that provides procedural protections of its application to personal use of personal automobiles. If the state cannot provide these sections, then the statute must be void, as overly broad in its intent and application, for want of clear, concise, and express terms. You got to put in your statute. If you want me to abide by anything that you talking about, you got to explicitly come out and say, which I haven't and we haven't seen, but contrary to the assumptions that one may think, the attorney generals have said the opposite. They have come out and stated that we don't need a driver's license. I mean, look at how many attorney general opinions we've read through in this series. It's hard to argue. So we just try to bring forth everything. This is the 11th hour into this series. So the power of the state to license, the power, which is limited, it doesn't supersede we the people. That has never been and never will be. Let's go to the governor right now and ask them if they state otherwise, or any representative of the people. They will never say that. Some who think they're sneaky and sly may act as though, but all will get shined to the light. So the power of the state to license and further regulate through the driver's license by acquiescence or consent, right? Private affairs is non-existent. So it has been laid down, this is a quote now, as a general rule that if the power of the state to control its highways has not been delegated and the state has prescribed no conditions limiting or regulating the use of the highway, the people are at liberty to use it for travel. Distinctions. Transportation. So if we want to engage in transportation, we can as well. Distinctions. By definition, and communication by any lawful means, subject only to the condition that such use neither interfere with other or similar lawful uses of the way, nor invade the rights of the owners of abutting lands. Unquote. 25 Am Juris Highways 169, Section 169, also State Ex Rel, Barlett versus Weber 88. Okay, so what we talking about? What that is clearly stating is the aspect that you can travel without nothing whatsoever, as long as what? As long as what? Subject only to the condition that such use neither interfere with other or similar lawful uses of the way, nor invade in the rights of the owners of abutting lands. And I would say even those next to you. You out here driving wild, bro, and like causing an issue. I could see the aspect of initiating some sort of stop to protect the public. But I ran your plate. It's expired, buddy. We got to tow it. What? What is going on, man? Are you okay today? Have you taken your meds? Come on, man. Calm down, dude. I don't think you need to take my property. You know, if you're just running some. What? Why are you trying to extort me, man? Can I just be? Can I just live? You trying to take my last dollar, man? It's all I got, dude. Like, leave me alone. The state of Washington State Supreme Court has already made it clear in the following case that the driver's license is intended to apply only to for-hire vehicles. The International Motor Transit Company case below must be read in pari materia with the rules of municipal regulation. Okay, let's see. I got to take a sip before I get into this one. Give me a sip. You know, we get to teaching. All right, this is a quote. Section 103. It shall be unlawful for any person to drive an automobile or other motor vehicle carrying passengers for hire within the city of Seattle without having a valid and subsisting license to be known as a driver's license. Driver's license, first class, shall entitle the holder thereof to drive any kind of class of motor vehicles for hire within the city of Seattle. Driver's license, second class, shall be limited to stages, sightseeing cars, or other motor vehicles operating over a specified route and having a fixed terminal. Now, driver's license, that third class, shall be limited to drivers of taxi cabs, for-hire cars, or other automobiles not operating on fixed routes and having a passenger capacity of less than 7 persons, not including the driver now. It is intended to apply to for-hire vehicles as provided in Section 6313 Rem Comp Stats are defined to mean all motor vehicles other than automobiles, stages, used for the transportation of persons for which remuneration of any kind is received, either directly or indirectly. And that's the International Motor Transit Company. Give me 1 second, y'all baby girl crying. Okay, that's International Motor Transit Company versus Seattle. 141 Wash 194 251 page 120. What's up, McDonald? What's up, McDonald? What's up, Kinetic Customs? How you doing, bro? As noted previously and further in this section, the requirement of a driver's license is for the operation and conduct of business. The research compiling this section procured no evidence anywhere, not in any state or federal regulation or judicial opinion, which extends the state authority in Title 46 RCW to the common man, requiring a driver's license to the use of a personal automobile to conduct personal affairs. It's just like what y'all talking about. Like, you really got to get on board with like understanding how these statutes are applied. If I do, I better not mess with that. Okay. Okay, so let me see. To the common man, requiring driver's license to the use of personal automobile to conduct personal affairs. Quote, a state is within its police powers. Now let's get specific here. A state is within its police powers by requiring a license as a prerequisite to the carrying on of certain activities commonly designated as business, occupations, professions, trades, or callings. 51 Amjurist 2D license and permits, section 14. It's very clear. It's not very hard for us to understand, right? So, again, we put these things into practice by defending ourselves. When we do so, as you've seen throughout certain situations, whether it be Hood River, right, where he admitted on camera, yes, you're a traveler, you're not doing commerce. When we're looking into the police manuals within Oregon itself, like that's what I've been doing recently. If you're looking on the community tab, that's what I've been doing. I've been putting these. Let me change this. How do I change this? I've been putting these. What I'm finding out here in the police manuals. I'm studying the police manuals for Oregon right now, right? Because what I'm doing is I'm getting everything prepared for the civil suit that I'm doing, right? The civil suit, you got to prepare for. I got to get my depositions right. I got to make sure that I am on point all the way with what I need to ask them. My depositions are going to go crazy. I'm not going to play with them because they get these manuals. And if you study these manuals, it teaches them already about the rights and what they need to watch out and what they are unable to do. Now that they've been taught, right, in the relationship in aspect of tort claims, which it goes into 242, the deprivation of rights, where the qualified immunity will be eligible. But what you got to understand too is the Chevron deference just is repealed. It's gone. So if you got the Chevron deference repealed as of 2024 this year in June, they can't rely on their administrative interpretations anymore. It's going back to constitutional, foundational, unalienable, inalienable rights that we have as natural law and creations of the Creator. And with that being said, it's open season to get as much out of what of the it's to get our rights upheld rather than what has been going on with the Chevron before June of 2024 of this year. So when I hear a lot of people, talking about, well, the courts don't do this and the courts don't do that, it makes me think in my mind, like, okay, well, what's been going on since the Chevron, though? Right? Like, what's been going on since the Chevron? Who's been getting out here and really, I'm hearing wins right now. I'm hearing a lot of wins right now across the board. So I think, I don't know, David, should you get a passport? That's totally up to you. I don't know. I'm not wanting to make no more pledges. You dig what I'm saying? Like, I'm good with what I got right now. I'm kind of good. I don't want to make no more pledges. Um, I'm already a California national, and I know how special California is itself. So just to be a California national, California is a holy land, yo. And yeah, I'm so grateful. I'm a California national. So I'm just gonna say it like that. I am the highest of authority. I am of we the people, just like you are the highest of authority, David. Um, you get whatever contracts you feel as though are beneficial to you or beneficial to you. And if that's good on you and you feel like making a pledge, you're good, bro. But I'm not making no pledges. I'm good. I'm a California born. I'm California born, bro. Like what? Do I need to get on some record to be known as, or just get my birth certificate authenticated? So yeah, we did that. All right, let's get into it. So we getting back to entire screen. Boom, boom. I'm authenticated, baby. All right, so let me see here. States have broad powers to regulate and license the practice of professions. That's it. That's all. National Pharmacies Inc. versus De Milicio. It is seemingly proper to reiterate the definition of the term license one more time for everybody, as the definition of this word will be important in understanding these statutes as they are properly applied in the courts or in legalese. Quote, the permission by competent authority to do an act which without permission would be illegal, a trespass, or a tort. How can you say something that we already have in which we're free to do is now? You see what I'm saying? We need permission somehow by competent authority. Are you we the people or are you a slave? You tell me now. What does this boil down to? Are you free or are you a slave? Because I don't think slaves have a competent authority above them. I mean, I don't think free men have a competent authority above them. If you have a competent authority above you, you've either done some sort of crime, okay, or you have submitted to some competent authority by consent. If there's no consent or contract, there is no competent authority above you, okay? And that's People versus Henderson. You got to start remembering, y'all, you're a creation of the creator, okay? So, quote, leave to do a thing which licensor could prevent. Western Electric Company versus Passant Reproducer Corp. So, are you trying to tell me that a state can tell me I can't live on and stand and do what I need to do as far as the right to travel? What do you mean? What? For what? Did you see me in the commission of? Oh, well, you got to be registered. Why do I have to have a allow you to have co-ownership and a security interest in my vehicle? You try to explain my automobile. You tell me how that makes sense. So for this definition to apply to a common traveler, a state would have to take up the position that the exercise of a protected right to use the public roads in which we all own in the ordinary course of life in business is illegal, a trespass or tort, which a state could then regulate or prevent. This position would raise fundamental questions as to the position would be diametrically opposed to the constitutional law. As recognized in this, the proper definition of a license is, quote, a permit granted by an appropriate governmental body, generally for consideration to a person, firm, or corporation, to pursue some occupation or to carry on some business which is subject to regulation under the police power, unquote. Rosenblatt versus California State Board of Pharmacy. So curiosity alone should question the authority of a state to impugn one for not having a public license for travel in the private. What reason could the legislature have not to include language and, in the history of amended legislation, purposefully delete such terms as business if it were not to confuse and manifest a clandestine subterfuge of fraudulently created business, which then a state could regulate? So, what I like about this one, when I start thinking about it, if I start thinking about it right now, what this one is essentially saying, if you gotta, when you start invoking the whole act rule, right? Let's say you invoke the whole act rule in some kind of filing to the court, and we start looking at that statute in its historical value, right, and what it was meant for and its purpose. And then we look to see that certain things were amended or omitted or taken out, such as business, right? When you see that, you got to understand, well, why would they take that out if it was explicit in its terminology by the legislature in the first place, right? Why did they explicitly state it was for commerce and business and all of these things that back us up in relation to what it is to apply to as far as our license is concerned, right? Because you, as the most highest of authority, the creation of the creator, you don't have to do anything forced upon you. That would be slavery, and we all know that. So a license can't be forced upon you, because to travel in your own property is a free right that everyone has. It's very simple to understand. I think the only aspect of when something can be forced upon you is if you cause harm, or you're causing some kind of problems to others, public safety. Um, but this right here says when you purposefully delete such terms as business, if it were not to confuse and manifest a clandestine or fraudulently created business, which then a state could regulate. What it also does is, by deleting those terms such as business and the specificities of the statute, now I really understand that we can use the rule of lenity in relation to it, or in conjunction with the whole rule act, right? So, or the whole act rule. And that is to bring both of those together, to intertwine, to say, look, y'all was very specific with the statute from the very beginning. I've studied it from all the way back. I've seen how people have tried to confiscate our rights to this day. And now, just by taking out business from the statute, when it's been very clear since its inception from the very beginning, Now it's just overly broad and vague. So I'm going to have to also invoke the rule of lenity. And then we're also have to going to go into the aspects of probable cause. These are now what I'm literally going how I would, like what if I'm going to the court, I'm bringing up all this. I'm gonna be like, I'm gonna be like, and then also the aspect of probable cause in any regard. Like there's no crime whatsoever. There's no verified complainant, and there's certainly no corpus delicti, which anyone can prove here. I mean, we get into the aspect where we understand now in the law. Now that the Chevron is gone, we really have all power to stand on everything, and knowing what has to be put in front of us before getting to the actual facts of the claims brought against us, we're going to start really standing on it as a people. And this comes from young to old. It's not very hard to understand the principles of life, liberty, and the pursuit of happiness. It is not hard to understand being free. If you're a good person and you doing good in life, it's not hard to get your freedom. You just can't wave it when you have demons, when you have people who are not in alignment with morals and who don't follow the simple principles of the Constitution. I mean, it is very easy to be a good person with respect, with honor, with morality, to do the best you possibly can for our community. And we have to do that on both sides. On both sides. We can't just be out here like putting that bad energy out into the system, into the realm. We have to be putting out the good so that we reap what we sow. And then when they combating us, it's like I'm trying to deflect that, educate, and then everybody's gonna move in a sound order. This is the only way we gonna get some movement and traction. It's not by butting heads. It's not by calling names. It's not by, oh, I'm better than you. It's by learning and applying and standing on that. Like, I ain't gonna tell you don't need no attorney, but if you can get yourself in a situation to learn and utilize the AI and learn with the community and learn with the people and study like we study it, we have a chance to change our nation for our children, y'all. These prosecutors are out here. I just uploaded a video this morning. These prosecutors are out here smirking and trying to place false charges on people just to make it stick, bro. Like it's just by the incident report and the police officer putting in false things into the incident report, man. Like it's not cool anymore. Y'all running people's lives by monetary gain. Like if anybody watched the video I uploaded this morning, that is prosecutorial misconduct. As soon as the video was viewed, they threw it away, the judge and everybody, after arguing so long about, do we have probable cause? Do we have probable cause? It's horrible out here. It's horrible out here. We have to do better. We got to stand on it, not just. Mm, mm. Let's get back to it. Share. Dang it. Preview. Okay. So, curiosity alone should question the authority of a state to impugn one for not having a public license for travel in the private. Okay. What reason could the legislature have not to include the language? Oh, yeah, we went through this. Such terms as business, deleting that, right? So, what the state may not do directly, it may not do indirectly. Bailey versus Alabama. Quote, a license fee is a charge made primarily for regulation, with the fee to cover the costs and expenses of supervision or regulation. State versus Jackman. So, shown above are the fundaments of a driver license. One court called out the distinction in discussing the public health and welfare as that being the use of the highway by travelers. Travelers is usually a short trip with a single departure point and a single termination point, limiting the amount of time on the highway. Where, in contrast, a driver for hire or other occupation or profession may spend several hours or days traveling public easements with several intermittent stops, whereby creating greater liability to other travelers. Quote, states have a compelling interest in the practice of professions and callings. It's business, and as part of their power to protect public health and safety, and other valid interests, they have the broad power to establish standards for licensing practitioners and regulating the practice of the profession. It must be business, not travel or living on free. Lender Service Inc. versus Daytona Bar Association against Dayton Bar Association. Certainly, the operation of business, the operation of business on public roads and streets by those individuals who use the highways in excess and extreme compared to the normal people like you and I, should be required to pay a highway or tonnage tax. What's spuriously deleted from the Motor Vehicle Act Reformation in the 1960s is the term chauffeur, discussed infra. It is the chauffeur that is the subject of a basic driver license, notwithstanding other delivery type occupations. The Latin term nullum simile est idem, things that are similar are not the same, is the suspect of a claim of void as to RCW 46.20. See RCW 46.20.050 or 55 of similar definitions following. Quote, I love Huddy on automobiles, so yeah, let's do it. It is necessary in order to regulate automobiling to pay the expenses of the department issuing licenses and registering drivers and owners of automobiles. These expenses naturally should be met by the class of persons regulated and licensed. Statutes which regulate the licensing of chauffeurs contemplate that an applicant for a license shall have received training in that work. Under a statute permitting an unlicensed person over the designated age to operate a motor vehicle accompanied by a licensed operator, such training may be possible. Huddy on automobiles, that's unquote, 6th edition, section 225, and quote, any trade, business, occupation, vocation, or profession may impose license tax upon persons or corporations doing business, unquote. Excerpt from John McGuire, Harvard Legal Essays, citing State versus Gowdy, 62, Montana. Oof, jeez Louise. Just because we similar doesn't mean it's facts, is what Kinetic Customs says on this one. So taxing power is exercised for the purpose of raising revenue and is subject to certain designated constitutional limitations. 16A Am Juris, 2D Constitutional Law, Section 318. So here we start to see the courts express the original intent of the statutes, which the legislature has conveniently scripted, classifying types of drivers and the tax revenue generated by the business they execute in their use on the highways. The question may be asked, does a state have authority to classify personal conduct as a part of commerce, like that of chauffeurs? No. Why? Because travelers don't collect a fee or charge a fare for traveling to visit the doctor, the veterinarian, the grocer, the hardware store, the beach, the coffee stand, a job, the bank, the school, other family restaurant or sporting events, or to see a movie, or to attend a funeral, etc. Ispo facto, if no fee is collected for personal affairs, then the state cannot impose a tax, which is de facto revenue, which is one of several intents of regulation for Title 46 RCW. De facto. They got that de facto revenue. It's all de facto. It's all de facto. So earlier, we encountered at AM, Juris 2D, Highways, Streets and Bridges, Section 227, and Huddy on Automobiles, Section 26, the term incidental. This term refers to the nature. How you operating out there? What's your nature like? You know, when they talk about that good old nature and cause, this term refers to nature of your commerce or of the commerce upon the highways. The courts, in their determination of the phrase incidental, have acknowledged the transpersonal, hyperbolic legal reasoning behind licensing statutes. Oof, what a sentence. When we look at RCW 46.20, the licensing statute for the state of Washington, we find no notice of the personal private use versus the private for hire that was formerly a part of the statute. Ah! That's a big one. Again, it's all about due process. I need that notice, please. Did you give me notice? Did you give me notice? If I ain't got no notice, you can't apply it. Because we're applying the rule of lenity around here, partner. Let's read it again. When we look at RCW 46.20, which I'm sure you can go somewhere and look within your own statutes, your own codes, somewhere and find, it's got to be something similar. The licensing statute for the state of Washington, we find no notice of the personal private use versus the private for hire use that was formerly a part of the statute. We're invoking the whole Rule Act on them boys. I tell you that right now. Quote, the fundamental risk associated with unbridled license schemes is the inability to detect the extent of the licensing statute in the absence of a narrowly drawn objective, I love it, and definite standards to guide the licensing authority. To guide it, you got to be definite. Whatever the motive which induced its legislative adoption, lack of strict legislative definition promulgates an overly broad legislative scheme and is therefore void for vagueness. Oh, let's go. Turn that void for... Man, y'all need to go back to the beginning. I'm jamming on this one. That one's jamming. It's void. It's void and it's vague, so it's gotta go. It's void. It's vague. It's void and it's vague. Get it out of here, no chord. Today, it's void. It's vague. It's void. It's vague. Get that coat. No, I got no coat today. Cause that doctrine and that thing that you say is really vague. What? Man, I'm talking about... No, get it out. We're not playing. Let's start it over. The fundamental risk associated with unbridled schemes is the inability to detect the extent of licensing statute in the absence of a narrowly drawn objective and definitive standards to guide the licensing authority, whatever the motive which induced its legislative adoption, and lack of strict legislative definition promulgates an overly broad legislative scheme and is therefore void for vagueness. The void for vagueness doctrine on the front end necessarily implies that the governmental intent of the statute must be made explicit in the text, not then subject to judicial law or administrative construction. Chevron is gone. You can't do it. It's not subject. This ain't Nike, bro. We not in Beaverton, Oregon. Unquote. See generally 16A and jurors 2D constitutional law section 527. Nope. Gotta go. We not just giving up our rights no more. We not just gonna wave up, here's my ID, and just take everything you want, and we'll just do what you say because you think you got authority, and you flexed at me, and you gave me a look, and you scared me, and I didn't just know what to do. You got a gun. I don't want America being in fear no more. I don't want no man or woman being in fear no more. It's not cool, dude. That's not cool, bro. That's not cool, bro. We should not be having people out here just willy-dilly out here putting other people in fear, bro. That's like a real deal PTSD thing, bro. It's not cool, bro. We gotta do better, man. We gotta do better, man. Like, for real. It's not cool. We gotta stop it. Everybody's gotta do better, man. Quote, however, in order to regulate In order to regulate, it says, it's giving us like the clearest language ever. The government may impose a permit requirement so long as the scheme does not delegate. Delegate means like force someone, an overly broad licensing discretion, right? To a governmental official. Therefore, any licensing scheme must be narrowly tailored to serve a significant governmental interest. Unquote. 16 AM Juris 2D Constitutional Law 527. So the question comes, is RCW 46.20.001 narrowly tailored? No, it is not. Not even close. This writer found the statute to be overly vague, and substantial research was needed to qualify the text and intent of the currently written statute. Ultimately, what was determined is that the currently written statute, including those prior, dating back to, and I would even say 1955, bro. Well, I don't know, because when I was looking, I'm all the way back to 1952 on some of the statutes I'm reading in relation to motor vehicle. At least on Washington side, dating back to 1968, classifies every single man and woman desiring to use the public highways as a chauffeur, aka driver for hire. That's very interesting. RCW 46.20.001 reads in relevant part, quote, no person may drive a motor vehicle upon the highway in this state without first obtaining a valid driver's license issued to Washington residents under this chapter. A person licensed as a driver under this chapter, A, may exercise the privilege upon all highways in this state. B, may not be required by a political subdivision to obtain any other license to exercise the privilege. And C, may not have more than one valid driver's license at a time. These interesting similarities between RCW 46.20.001 and the pre-Reformation statutes are these. 1. A person licensed as a driver. 2. May not have more than one valid driver's license at a time. These sections, as written, are expositive of the spurious attempt of the legislature to conceal the actual purpose of the licensing statutes. Licensing statutes must provide notice as a purpose and intent. Where's the purpose and intent in this statute? It just says for the privilege to exercise the privilege. What privilege? What privilege? What privilege? I need to know more. What privilege? The privilege may exercise the privilege. What privilege? What privilege? You tell me what privilege? I need a privilege. It's so vague. Rule of lenity. And the Washington state legislature has intentionally done exactly the opposite. So comes the question, is the state attempting to regulate personal use of personal property? Sure seems like it. Maybe the state would like to license and regulate the type of shoes a man can wear on the public easements. Sure, why not? It is established that many things qualify as vehicles, as the Loeb case of a U.S. passport. Quote, the legislature can, in the exercise of its police power, regulate and require the licensure of professionals as it sees fit. But any law in furtherance of the public power must be reasonable and not arbitrary. Unquote. 51 Amjur's 2D licenses and permits, section 14, citing auto realty servicing versus Brown. What do we got next? Okay, and it says the means or mode of traveling may be subjected to reasonable regulations. Means or mode, Benning versus state. As noted in the Benning court above, the state may regulate for the safety of the public health and welfare to protect the public health and welfare. However, as discussed, supra, the choice of vehicle is for individual determination and use, not then subject to state license or ship. Tell them. Tell them. So, the shoes people wear are in fact vehicles, same as the automobile or skateboard, and as such are subject to state licensing. The state can no more require a license for the use of shoes than they can require a license to ride a skateboard or the use of or use a personal automobile. Excuse me, golly. Okay. Commerce is simply defined as payment, delivery, receipt. Intercourse is the giving and receiving. Intercourse is the giving and receiving of that which is mutually beneficial. What constitutes commerce upon the highways is one of two usual scenarios. One, purchase point of origin delivery, transport along the highway, and payment receipt at a terminal point, as is defined of shipping vessels in maritime admiralty. And then two, purchase hire of a third party vehicle on the highway for delivery along the highway, payment on receipt, compensation for use of the third party vehicle on the highway, right? So here we go with them good old quotes that comes out of Huddy on automobiles. This is coming out of the 6th edition, section 86. You can follow along with me here. Quote, commerce of commercial intercourse. No, commerce consists, of commercial intercourse. It must be conceded that interstate travel for pleasure and recreation does not savor of anything commercial, y'all. Okay? They're already telling us in all of these opinions within the books of law. It's already established. Okay? This is why we need to get over the ignorance of the indoctrination and programming that we have been led to believe, because it's not accurate whatsoever. All of these things have been spoken about in great detail. Okay? It is not business. It is pleasure and recreation and nothing more. The greater amount of interstate automobile travel is for the pleasure and recreation. Business and the pecuniary gain have no connection with it. We will consider briefly in the note of meaning of the term commerce and ascertain if the travel must in some way be connected or related to business, a trade, or a gain. Now, it is the opinion of many persons that Congress possesses no power to take cognizance of the automobile which is engaged in interstate travel for pleasure merely by legislation directly regulating that kind of travel. Okay? Then again, another quote, regulations which might be an unreasonable infringement of the common right to use the highways. In the one case would be proper when applying to one seeking to use the highways as a carrier of passengers, a carrier of passengers, unquote. LeBlanc versus New Orleans, 138. Also, Chicago versus Banker, as well as Hudson versus Des Moines. Infra. Moreover, it has been held that as a prerequisite to one operating his automobile for pleasure on the public highways, this is a quote as well, y'all, the city of Chicago has no power to require a party who uses his automobile for his private pleasure only to submit to an examination and to take a license out for it. Huddy on Automobile 6th edition, which is citing Chicago versus Banker. And people will sit here, they've repealed that and that don't stand anymore. I don't care who you think you are telling me that my constitutional liberties that are God-given as the highest of authority and part of we the people which govern you can tell us how the hell our rights are going to be sitting here and limited. This ain't up for debate. We ain't going to sit here and argue about our rights, dude. Y'all can go argue that in the courthouse. Don't sit here and bring your claims against me because you won't make money as a corporation on the municipal side of things to come violate my rights as though I don't know what the hell my rights are. Who the hell you think you are? I'm not a slave. I ain't ever going to be a slave. I will always be a peaceful person to uplift the next person by giving as much knowledge and anything that I possibly can. But I will not stand for someone trying to impose even the high. I don't care if the president came to me, bro, and told me to bow down. I ain't bound. You understand that? Ain't no one above me. We are all collectively on the same level as far as authority is concerned. So while I ain't above anybody else, ain't nobody above me either. We're all equal. You get what I'm saying here? This is America. This is America. Discussed here, again, is the personal use of dictum versus the for hire dictum. Title 46 RCW Chapter 20 is overly broad because it presumes to notice the public. Conversely, the public assumes by the vague language that all are subject to the statute, licensing guides. Do you see again how ambiguity or vagueness can be applied in the courts to get things dropped? What is relevant in this statement is that Washington courts have ruled on class distinctions several times. Several times. It is well settled that the equal protection of the 14th Amendment to the federal Constitution does not take from the state the right or power to classify the subject of legislation. It is only an arbitrary and unreasonable classification. Classifications to which there is no just difference or distinction between the class affected and others that is thus prohibited. Huddies on Automobiles, 6th edition. Citing State versus Seattle, taxi cab and transfer. Allen versus City of Bellingham. McLaughlin versus City of Seattle. The quote, the legislature has ample power to compel the owners of motor vehicles used for the carriage of passengers for hire to procure licenses. Do you hear all those commercial terms? All of those were commercial terms. Motor vehicles, carriage, passengers, for hire. All of those. 3 different elements right there. All of those. It's the only way they can compel you. Why? Because we, the people, dictated it. If you're using our roads to get money, you got to pay up. If you're causing traffic, you're damaging the roads. Pay up. We got to deal with you now. Let's get some better highways and roads in here. Y'all get this management system up. Hello? That was the whole point of the Department of Transportation. And this is Hudson versus Des Moines as well. Quote, the fact that the operator of a vehicle has taken out a license to operate it for hire does not raise any presumption that he was actually engaged in that business at that time of use. So even if you got one, City of Chicago versus Gall. See also Huddy on Automobiles, 6th edition. No license is required to use personal automobiles for personal affairs, and no state may coerce or otherwise mandate a license to exercise personal liberties whatsoever. It seems appropriate to discuss when and to whom a license is required. To follow this discussion, notice the language below. Persons driving motor vehicles. Now let's digress to RCW 46.20.001, previous and the language thereto. In the first subchapter, we see the language, person may drive a motor vehicle. Relevant here is the reference to the Stork Court. Persons who drive for hire, aka for compensation, for hire is for compensation, are the proper and only subject of legislation. They've made it clear. Chauffeur, the term in legal significance means any persons, which is business, doesn't mean people. It can mean business, corporation, LLC, trust, organization, foundation. It can be lots of things in legalese. Operating or driving a motor vehicle. Oh, thanks for putting them italicized now. As an employee for hire. Should have put both of those italicized too. Huddies on Automobiles, 9th edition. Section 27 definitions. The occupation of the chauffeur for hire is one for which, under the police power inhering in legislative bodies, may properly be a subject for regulation. That's it. That's the type that can be regulated, is these type of people, the occupation. Okay? Under the police power. Huddy on Automobiles. Matter of Stork. Quote, under its powers to regulate the use of the streets and pass and enforce all necessary police regulations, a city may require the drivers of automobiles used. This is very clear now. Don't try to make it broad. A city may require the drivers of automobiles that also must be used in transporting persons or property for hire to be examined and licensed. Huddy on Automobiles, 6th edition, section 221. Okay. In 1968, a major reformation was undertaken affecting the motor vehicle acts of many states. Of special note here as to the strict distinction of who must possess a driver's license. In the latter half of the paragraph, one below, it is made clear that those chauffeur drivers currently in possession of a license will remain current until such time as they come to renew, subject to new codification. Every driver's license issued after 1968 is issued a chauffeur or driver for hire, notwithstanding the substitution of the word driver in place of chauffeur. The state of Washington Department of Licensing issues thousands of driver's licenses every year. It is a realistic presumption that every man and woman who gets a driver's license is a driver for hire, or is it fraud? Or is it fraud? If it is a realistic presumption, there is absolutely no cause for any man or woman to be unemployed. I won't get paid. However, as this all applies to the state of Washington, the following is published and known. Quote, prior to 1968, Chapter 6 provided for the issuance of operators licenses, and chauffeur license. This distinction was discontinued in 1968 in favor of licensure based on the type of or general class of vehicles to be driven by the licensee. It is also suggested that each state consider adopting a law providing that all operators and chauffeur licenses issued prior to the effective date of the revised Chapter 6 in 1968, which is funny because, again, that's another 666. You got that 1 over here to that 8, and that's a 666, shall remain valid until their normal date of expiration or the dates of expiration shown on such license cards. Further, attention is directed to the fact that this section referring to any person driving any motor vehicle is sufficiently broad by reason of the definition of motor vehicle in section 1134. Uniform Vehicle Code and Motor Traffic Ordinance, Chapter 6, 1968. Another quote, throughout the years of its existence, the code has reflected provisions of state driver's licensing laws, and in turn, many state laws have reflected the visions of the code. Give me one second. Although there has been less conformity with the code in driver's licensing laws than in the rules of the road model traffic ordinance, nevertheless, many state driver's licensing laws can be categorized on the basis of similarity to a provision which is now, or has been in the past, a part of the Uniform Vehicle Code. Further, hence, the development of the code should be of general interest and that it mirrors the evolution of driver's licensing laws in this country and may be helpful in improving or at least explaining existing laws. Unquote. Driver's licensing law annotated in 1980, hereinafter DLLA, U.S. Department of Transportation, National Highway Traffic Safety Administration. You got to understand, traffic's another commercial term. All these terms they use are for commerce. So, the state of Washington was a major supporter of the UVC and MTO. The definition contained in the Federal Motor Vehicle Acts is not of irony, identical in the preceding reference to DLLA, which uses the object definition of motor vehicle contained in the Uniform Vehicle Code and Model Traffic Ordinance definition, section 1-134 motor vehicle, which reads, quote, every vehicle which is self-propelled and every vehicle which is propelled by electric power obtained from overhead trolley wires, but not operated upon rails. Unquote. Unquote. I ain't driving no trolley. What y'all talking about? Y'all give me some of them power trolley wheels so I can go along the roads without having to spend all this gas then. If that's the case, well, what y'all mean? Yeah, I want a real motor vehicle. Give me this definition of a motor vehicle. I want this one. Give me some free miles, okay? Y'all put them overhead trolley wires above me, man. That's how I'm trying to operate. If y'all want to put me inside of a classification of motor vehicle, shit, what you mean? Give me the power. Give me the juice. Dude. All right, let's see. That's good. What was done? In the mid late 60s or mid to late 60s, having several revisions to gain nationwide acceptance by 1968. I don't believe that because the number's so uniform. In its numerology, was to combine the operator's license with the chauffeur's license as a taxi cab company operating vehicles for hire and the drivers paid to transport people, creating one license. The term chauffeur, French in origin, was deleted and replaced with the English common term driver. What did not happen? What did not happen? Citing from the sources below is the presumptive, all encompassing graft of every man and woman who may use their personal automobile and subject them to a driver's license. Yes, do you hear that? And subject them. Are you a subject to anything or are you free? You holding that hand up at them football games, at them wrestling matches with your kids, at man, when we standing up at all games to hear the national anthem. Does it say that we are subject to anything? Does the Constitution say we are subject to anything? Or does it say that all power is inherent in we, the people? Is all power inherent in the people or not? You tell me. They will say, oh, but there's rules. Yes, the rules are applied for harm and crime. That is it. If there's nothing else, live and let live. Let me see here. Here again. Here, once again. Deference to RCW 46.20.001. And the language thereto is prudent. Subchapter 2C reads, may not have more than one valid driver's license at a time. 40 years later, this statute bears a striking resemblance to the 1968 Uniform Vehicle Code. The code was extensively amended in 1968 to form the current Section 6-101C by eliminating the operator chauffeur distinction and by clearly applying the one license concept to all licenses issued under the code. DLLA Infra. Quote, here we go. And this is from the DLLA Supra. Okay. And this is why it's good to have all of this stuff because, yeah, administrators do not know law. They don't. But what's amazing is that we do. We know what's cool is that, this aspect is just reinforcing everything that we already know. We already have we already know we got our constitutional rights. That ain't no issue here. That ain't right now. Like for most people, I don't think that's the bigger thing. I think the bigger thing is just having everything to reinforce what is being said here. I think if we just have the power and the know-how to reinforce everything that's being said here by retaining the information and knowledge, by being able to stand in our own power, right? We just have to be able to stand in our own power. That's the biggest thing, is the fear and intimidation that when we're doing what we're doing, that, we're going to get, violated, or that we don't have the capacity to come out here and represent ourselves. We're on hour 11 coming into now hour 12 through this series. And through this series, we're reading something that is giving us a great understanding in every aspect and facet that can be possible. I mean, we're clearly going through every avenue and angle. And what you have to, I think, really understand, just like I understood, is that things can only be charged against you if you first off have brought harm to another one, to someone. But another element also has to be brought forth, which is the aspect of consent. We are the highest of authority, and if no consent has been given, meaning a contractual agreement of any sort whatsoever, there can be nothing that's forced upon you, because if that's the case, it would be included as slavery or involuntary servitude, right? Like, they can't do that. Nobody can force something upon you. That's not how this country works, y'all. And you have to understand those principles. It's all about contract and consent. And our deeper people, our people at the higher realms understand that. Maybe not when we go in to talk to a lot of clerks, but sure, I'm sure a lot of clerks do. I know a lot of administrative judges are not wanting to respect our rights and us knowing this. But again, the Chevron deference is repealed. The only problem is we haven't been enforcing these violations that have been occurring on our behalf because we didn't know the violations and the rules in which they happen, right? And I think once we start going after the prosecutorial misconduct, the criminal negligence, or the criminal aspects of what's being placed upon us, we can start enforcing those, because the Chevron deference is repealed. The district courts, on state and civil sides, are really going to be beneficial if you can articulate yourself well by utilizing the help that we can provide, what I'm saying, through our community engagement through ChatGPT Pro mode. And I think that's just what is so beneficial to our community, is being able to freely give the knowledge to all, to where we can start to develop and implement these things to end the tyranny within our country and build a unity and a bridge between us so that our children don't have to live in fear. It's not okay for people to live in fear. It's not okay for people to be intimidated, to obey and command. It's not okay. We have to stop it. I mean, it gets to the point where they're lying. We know of the travesties that occur. I, I just feel like, as a people, as one, all together, um, just without any color blurs or culture lines, any state lines, we can all agree that we are one creation of the Creator. And if we can come to that deep understanding and comprehension, or understanding and comprehension and overstanding, then we can end a lot of the suffering that's occurring upon our nation. Because I'm telling you, man, I'm gonna tell you something real quick. So with Luis's situation, right? And I see you on the chat. What's up, Tight Screens? What's up, Dark Renaissance? What's up, Hourglass? I see you still in here, Kinetic. What's amazing to me, y'all. If y'all got any questions, y'all let me know. I'm gonna open up, make the chat a little bit bigger and take a quick. We'll talk. What's up, Duran? Um, Duran Beckford. Who else in here? What's up, David Haas? I see y'all. What's up, Vicious? I see you again in here. Mitchell Evans still in this bad boy too. Hopefully, I don't know. Chat's been kind of, but you know what I'm saying? What I've done is, when I was reviewing Luis's situation, I recognized that one of the sheriffs is named Jason Lee, right? And I reached out to Luis and I was like, hey man, can you see if you can help me find Jason Lee, like how to reach out to him? And uh he found him, and I reached out to him and I was like, yo, Jason Lee, I was like, bro, I heard you in the thing with Luis, right? And I could tell that you can be a good person, man. I hear you talking about that your uncle's a constitutionalist. And then when I'm looking on Homeboy's Facebook page, he's got comments from a picture, and the comments are literally talking about 32 weeks ago now, how people remember how Jason Lee is preaching in the church and how good of a job Jason Lee was preaching in his church. Now, I'm not involved in any religion. You can feel whatever religion you want. But just the aspect of, if you're giving your time to preach in the church and other people are coming later and saying how good that they thought that person was, that kind of tells about maybe someone's characters or morals, right? They're trying to instill knowledge and education and good morals and integrity. It's something they feel as though is important to them, and I'm sure it is. And like I said, I reached out to that deputy Jason Lee and I told him, man, like, you have a chance to be a leader here and instill doing something right, and every one of them do. And we have to really reach out to our other community members. These are our people. I don't see color lines no more, bro. I understand that we are all one. And then we come and we go. I've been here several times. And you have too. I think we got to realize that. And once we tap into that source of knowing that we've been here several times, and this isn't just an on and off type thing to where we can just be ruled, ridiculed, and be subjected to um, such ill travesties. They just say conform and comply and just do as you're told. That's not how this goes, my guy. I want to be as polite and respectful as possible. I don't want to fight you. I don't want to argue with you. Like, I'm going to stand on my square here. I'm going to be firm on who I am. And it's because I know who I am, just as much as you should know who you are, just as much as you should know what your children are, right? You would never want an individual in any capacity to sit here to talk to you or your children in this manner. And just because you have that badge on, you shouldn't do this in any such way to me as well. Because again, we all creations. And it's hard for me to get over the hump of that aspect first. When respect is given, why is it not returned? And I think when we go into issues, like, if we go into at least me, if I go into issues of using the Eddie Craig script on not waiving any of my rights, if I go into any aspect, what's going to be good? Is it going to be me trying to argue with the what's going to what's going to look good on video on jury trial or discovery or depositions? Do you see what happens? I understand people may be like, well, Cameron, what happens if, they come out here and they tow your car and they violate you and they break your window? I have enough of my savings account to get myself out of that situation and sue the living crap out of them. I'm not worried about them violating me. They're not going to kill me because I'm not going to resist. I'm just not going to waive my rights either. You get what I'm saying? I'm not going to fight them and I'm not going to argue with them, but I am sure not going to let go of the millions of people that died for me and my freedoms. That's disrespect right off the jump. If I bow and waive my rights, I'm disrespecting the millions of people that literally fought for me. I am a descendant of those millions of people that died. Do you understand that? We are all descendants of people that have died. We've come and gone from this country several times. This country has gone up and down several times. So we are all one. And in being one, we need to understand that we need to treat each other as one. It's not hard to understand. We need to comprehend that certain statutes and certain people, like prosecutors, I don't want to always be like this, but they have a very evil job. You can see it. They have become, I just, like I said, I uploaded a video this morning. They've become very bad in relation to prosecutorial misconduct, where they will go outside of a statute. And if a lawyer is just working with the state on some kind of back end deal, they will, again, the first lawyer didn't work with the client whatsoever, didn't stand up for his constitutional rights, and they probably didn't have probable cause, and the case probably would have been dropped, to the next lawyer that comes through and gets the thing completely dropped, which we can do ourselves just by knowing what we need to argue. So it's real important, I feel like, that everybody across the board is able to retain information at in every aspect, because that is the only thing that is stopping us from being able to retain our rights, is education, knowledge, and that's by not waiving your rights. So, a valid driver's license in 1968, the code abandoned the distinction between the operators and chauffeurs licenses and combined these two categories into a single driver's license with classifications based upon the type of vehicle the licensee is qualified to drive. 31 jurisdictions follow this code concept by issuing just one basic driver's license and by not making the distinction between the operators and the chauffeurs. DLL Supra, Section 6 through 101A, including the state of Washington. Quote, hold on. The one license concept expresses that every person has but one privilege to drive, and no matter how many different types or classes of vehicles a license has been qualified to drive in his home state, all types and classes will be noted on one license card. Okay. The issuance of one license card to a person for a motorcycle, another card for a passenger car, and another for a tractor semi-trailer combination is not recommended because of the inconvenience and enforcement difficulties that would result. Thank you for the distinction. DLLA Supra footnote 4, section 6 through 101C. Quote, this annotation covers state laws which provide for license classification for special licensing based upon factors of vehicle type, or factors of vehicle use to transport persons or property for compensation, or a combination of such factors. DLLA Supra Section 6-104, Statutory Annotation, Subsection A. Quote again, in Washington, the law provides that the director of the Department of Licensing shall adopt rules and regulations and standards pertaining to a determination of what types of vehicles require special skills for the operations thereof, taking into consideration the extent to which a special knowledge of traffic laws, it's like we have to have a special knowledge now, which I guarantee you, if you've gone through this with me, through all of this series itself, there is no way that you are not more educated than any person that is on a police force in relation to. There's no way. You can't tell me that they are taking this much of in-depth course in relation to traffic laws, definitions, and how they work. I bet you can go to an attorney and say, hey, man, I just wanted to talk to you about this real quick and see, I was having this conversation. I got this case. Yeah, man, it's traffic tickets. And, I was looking in DLLA super section 6-104 in subsection B, and it was telling me that, in Washington, the law provides that the director of the Department of Licensing, it shall adopt rules and regulations and standards pertaining to a determination of what types of vehicles require special skills, for the operations thereof, taken into consideration now. Okay. You got to take it into consideration. The extent to which a special knowledge, of course, of traffic laws, I've got this special knowledge now, lawyer. I'm telling you now, because they all pertain, you see, to the type of vehicle and a special ability to maneuver. You got to have specials in this because you got to make sure to know how to do those big turns on those special vehicles, because it's all commercial, you know what I'm saying? But when it comes down a little, you got to have special knowledge and nothing. But, the special ability to maneuver such vehicles, it's got to be necessary for the safe operation because they're big, you can't see. And they got, big wheels and go over people. And anyways, so for the safe operation of the vehicle, both alone and in relationship to other types of, those common automobiles that everybody's using, like, my personal car, on vehicles on the road. Unquote. DLL Supra section 6-1 through 4 subsection B. Okay. You get what I'm saying? So it's all about, they're not going to even know what you're talking about. Every time an executive employee stops, detains, interferes, and harasses a traveler on the common highway, that employee invokes and uses commercial licensing policy to coerce the traveler into believing that the personal use of the common highways by a personal automobile is illegal, and he has authority to deter such further conduct until such time as the policy is complied with. Policy, policy, policy. The illusion of the necessity of a license to use a personal automobile is per se banishment from the free use of the public highways. You understand that? So if you're saying that that I have to first get a license, you are then by saying I am banished first for free use of the highways in which I own. So you're saying I own the roads, but I don't own the roads at the same time. Which one is it? You're saying these roads I own, right? Oh, yeah. Oh, okay. But you're banished to use them until you get a license, boy. You better get one. That makes sure you're safe and we know who you are so we can charge you. If you don't got one, we can't cite you. We can't get you on all those rules and regulations that we get for all those big rigs and trucks and traffic and trade and commerce and tab cabs, you drivers. Man, they be tripping out here, yo. It's an illusion. The state police stop people at random for all traveling issues and issue traffic infractions for no valid operator's license and arrest people and impound their personal property for allegedly driving on a suspended license that they never applied for. A suspended privilege. It's a suspended privilege. People are literally getting their private automobile that has no registration, no title, no contractual agreement with the state on a suspended right to apply for a privilege. That's how wild they've gotten. It has gotten so far away from the underlying aspect of a contract. It has gotten so far away from the underlying aspect of a contract that they have said, okay, so we'll say you're driving on a suspended license. Okay. Now you're driving. If you don't have a contract, you're driving on a suspended right to apply for a privilege license. You're suspended on your right to apply for the privilege. How do you get suspended on your right on just to apply when I never applied? So you're mad at me that you're charging me for a license that I've never had on a contract that has never been brought forth. You're charging me for that, and you're saying I'm guilty of it, even though I wasn't doing what you're saying. I'm not driving. I have no contract. Then you're going to say, oh, well, we're going to suspend your right to apply. What? You can't suspend the right. What are you talking about? Oh, I can't deal with the logic of how anybody could think that could even apply. It is brain dead. You can't suspend a right to apply, bro. What are you talking about? I got a DMV thing somewhere around here that says that. I swear it. I swear I have one somewhere. I'm just flabbergasted that we don't see things for what they are. Okay? We have to see them for what they are. They're illusions. Illusions. The illusion of necessity. Oh, I'm not on the screen. My bad, y'all. Let me get on the screen. The illusion of necessity. Illusion of necessity. Okay? For the purpose of discussion, if an individual should have the unfortunate circumstance of not paying a traffic infraction, and as a consequence, perhaps the driver license is suspended or revoked, consider RCW 46.20.245 driving while license suspended. This statute penalizes the driver for traveling the common easements in a personal capacity with a monetary fine and incarceration. That's crazy to me. Like, what? Oh, wow. If this isn't a treason and trespass of your rights, I don't know what is. Now that we understand the basic principles and foundations of what we have as far as our secured liberties is. If you're getting taken to jail in 2024 leading into 2025, your education needs to be on point so much that you are now bringing forth civil suits. Stop playing with them. There's no reason for it. This is done via presumption. This is done via presumption. This is done via presumption that because one was traveling to common highways, one must have been driving by definition. The right to travel includes the freedom to enter and reside. This is a quote now. In any state, in a state law implicates that, that state law, that state imaginary line from one line to the other. That, no. You see what I'm saying? Because you know what that would require? If I'm going through state to state, that means that I now have to get some kind of regulation placed upon me and my car within every state. Do you see what I'm saying? Do you see how that's right? So and then I would have to be put on notice. It just does. It could never work, especially for the right to travel. The right to travel includes the freedom to enter and reside in any state, and state law implicates that right when it actually deters such travel. When impeding travel is its primary objective, or when, as here, it uses a classification that penalizes the exercise of that right. They're leaving it to you right here, y'all, in case law. When the latter is involved, heightened scrutiny of the law is required to determine its constitutionality. When the latter is involved, the exercise of the right, when the latter is involved, the exercise of that right. What right? What right? What right? The right to travel includes the freedom. Okay? Heightened scrutiny of law is required to determine its constitutionality, and the state must come forward with a compelling justification. Where's the justification? Okay. So, Attorney General of New York versus Soto Lopez 476. This is in 1986. So don't sit here and be like, we don't get much trolls, which is really amazing. And I think the reason we don't get much trolls is because, we read very heavily on things that we can bring exact knowledge to. It's not just conjecture. It's exactitude, and that's what's beneficial to all of us, is the exactitude of actual law, to make sure that everybody is well informed, so that we're not advised by people who are not informed or teaching properly, or at least reading the constitutional, or at least allowing people to know their constitutional rights properly, by just telling them that they need to hand over their license and registration and give everything up. That is the worst thing that you could do. You have essentially waived a shitload of rights just by doing such, that you essentially can't get back. You've given it up. You've waived them. And I think by waiving those rights, you're putting yourself into a worse situation, because you are then justifying that there was some sort of authority over you. And when you come into, let's say, if something was to happen in that situation, if you go to civil court, you're screwed, dude. You waived your rights. You consented. Yes, if it gets to some certain aspect or level of heightened harm or damage, yeah, maybe you can still go towards for the civil, but in certain other aspects, literally in the courts, they will say no, sir. It gets very exact in relation to, did you give consent? Did you give up your information or did you waive? Right? So that's some things we really need to realize is waiving our rights or not. And if people are telling you to give up your information as soon as you get into a traffic stop, and to act in fear and scared, and that should never, that's wrong. It's totally wrong, dude. You need to stand up on your liberties. You need to know who you are and what you are. You are the highest of authority, especially if you've done no wrong, especially if you're not in the commission of a crime. The decision in Dunn versus Blumstein, makes clear that the right to travel is a fundamental right violated by classifications which penalize, not actually deter the right to travel. And the actual deterrence was not a factor to be considered in deciding whether a penalty was imposed. Egert, Supra, citing Vaughn versus Boer. Okay. Also, Turner versus Fauci, maybe. The people have a right to travel uninhibited. The common highways. That right is prejudicially barred when the state or local armed police stop and arrest based on a statute that is factually designed for compensatory drivers. Let's say it again. The right to prejudicially barred. That right is prejudicially barred when the state or local armed police knowingly and willingly, which cannot now fall under qualified immunity, because we have found within their manuals that they know the difference, because right under their manual in relation to, what is I'm thinking, Cameron? Oh, when it comes down to, I just posted it on community tab. What is it, Cam? It's the aspect of suspended license. It literally says commercial, applies to commercial vehicles only. So they're prejudicially barred when the state, knowingly and willingly, those local armed police stopped and arrest based on a statute that is factually designed for compensatory commerce drivers. Theft of personal automobile is loss of personal property. While the personal automobile is an impound, an individual is forced to use alternative methods and modes of transportation. So RCW 46.25 does not have a subchapter for the suspension of a commercial driver license. A suspension of a commercial driver's license is effected through RCW 46.20.245. This represents proof positive that RCW 46.20 is in fact a commercial licensing statute. Quote, other illustrations could be included, but it is readily apparent that when one is deprived, that's a strong word. Deprived. Oh, that is so strong. Because what does that fall into in our Constitution? No person shall be deprived of life, liberty, and the pursuit of happiness. No person. No living being. Other illustrations could be included, but it is readily apparent that when one is deprived of the use of his automobile today, for all practical purposes, his mobility is seriously impaired. Not just his, but his family, if others are involved. Admittedly, he may be able to locate public transportation, not out in the middle of nowhere. Deputy Swim, Deputy Fellner, Deputy Lee, such as a taxi or a bus, a hard financial burden. Maybe they didn't have the money to get a taxi or a bus. But in many instances, it will not be available when needed. Furthermore, as we have seen, the constitutional right of mobility is an individual, personal right, which is not protected, but de facto restricted if he is forced to use public transportation. What? What does that just say? I am confused. What does that say? Furthermore, as we have seen, the constitutional right of mobility is an individual personal right which is not protected, but restricted if he is forced to use public transportation. A book on legal nature of driver's license. I was like, what? At first. As a general rule, any law subjecting the exercise of a liberty such as a freedom of movement to the prior restraint of a license, infringes on that freedom. 16 enters to the constitutional law, section 527, which is exactly what I say all the time, just in different terminology, which is administration and trying to administer a free man is repugnant to his freedom. You can't have both. You can't try. I can't be free if you're trying to administer me and telling me what I need to do. It don't make no sense. It's the same thing here. As a general rule, any law subjecting the exercise of liberty, life, happiness, such as the freedom of movement, it's right here displayed. Any kind of movement, bro. If I want to get into a hovercraft, I'm gonna get into a hovercraft, and you can't restrict that. If I want to get on a boat, I'm gonna get on a boat, and you can't restrict that because I am a living being. To the prior restraint of a license infringes that freedom. Just by trying to tell me that I need to have a license is infringement on my freedom. So when you come up to me and you say with your false presumptions, right? When you say, well, you need to have a license, it's a failed carry to present. Right there, you're infringing on my freedom because you are falsely using your presumption, trying to state that I now am below you. Now, check it. If you don't rebut that, then they're going to assume authority. What do you do in that situation? What would you do in that situation? What would any normal person in that situation? You're going to rebut the presumption, sir. I'm going to have to rebut any presumption that I have to do anything at this point in time. What I'm also going to do is I'm going to reserve all rights, including my right to remain silent, and also have any kind of counsel or co-counsel present at any further point. Please do not ask me any further questions, as I will not be answering them for you today. And unless you have probable cause or reasonable suspicion of any crime that has currently been committed, I am going to leave right now unless I am being detained. Am I being detained by you, or am I free to go, good sir? Oh, you're being detained. We're investigating you. So go ahead and give that. Okay, good sir, then I'm going to remain quiet. I cannot help you any further in your investigation, sir. Thank you. Done. If I'm out and about, you see what I'm saying? If I'm walking, that's how I would be. Done. If I'm in my car, we're going through the Eddie Craig script. You'll see it. It's there. Eddie Craig script. That's all you got to look for. It's called transportation script. The best. There ain't nothing better than that script right there. Highly recommended. Don't worry, we getting Eddie Craig on soon. Don't worry, we getting Eddie Craig on soon. Y'all don't trip. We getting Eddie Craig on soon. Because we can try and get my boy on the show for the Operation Wise Dome. Get him in there for a while. Thought that'd be more beneficial for everybody if he was available to the public, right? To the rest of the community. Again, remember tonight, Operation Wise Dome is at 6 p.m. Pacific Standard Time. It's our gathering, y'all. It's our gathering of everybody. We come in, we help people, we utilize ChatGPT to get answers and questions and develop all kinds of hypothetical situations, templates, and things that we can utilize and that we are utilizing to help us further our own development and understanding and things that we need currently with fighting corruption, right? With exercising our rights and making sure that our secured liberties are enforced properly. Okay? So, one's right to travel is severely limited if he is forced to constantly wait for buses or taxis. Thank you. Both of which would create a financial hardship. Thank you. For then, the right to travel freely with the use of ordinary conveyance of the day is then subject to a fare or fee, which is a state dictate for an individual to pay for limited and restricted exercise of a right. So, where was that? Oh, wait, of a right. Yeah. Strict scrutiny is the most rigorous form of judicial review. What is it? Strict scrutiny is the most rigorous form of judicial review. So this is interesting because when we go into bringing up certain topics, like let's say, I was talking to Luis the other day and he's going through this motion with me, right? And he's bringing up a lot of different things on things that he's found. We're going into manuals. I'm going into manuals on my side of Hood River with my civil case. He's going into, police manuals, Washington State Patrol and all, sheriffs over on the Washington side. And we're just going through everything. And again, everything has to be so strict. When you're filing your things, the judge, after you file a motion to dismiss, you can also file that proposed order of a motion to dismiss for the judge to clearly look at your motion, look at all the elements, look at what the state's presenting, and then you already have a proposed order ready to go for the judge to sign off on and say, you know what, I can't go against what the defendant has said here. Because the statute is overly broad and you're trying to present it on something you said, which is a basis of okay, I'm sorry, I'm ranting. I'll just get to it. So a fundamental right worthy of protection by strict scrutiny. Again, that statute has to be very strict, has to give good notice. It has to give exactly everything that is included and cannot be overly broad. Once a court determines that strict scrutiny must be applied, it is presumed that the law or policy is unconstitutional. Okay. The government has the burden of proving that its challenged policy is constitutional. To withstand strict scrutiny, the government must show that its policy is necessary to achieve a compelling state interest. If this proved, the state must then demonstrate that the legislation is narrowly tailored to achieve the intended result. Give me 1 second. I got to put my computer on quiet mode. People calling me. So do not disturb. Okay. For an hour. Okay, cool. Okay. So if it is proved, the state must then demonstrate that the legislation is narrowly tailored to achieve the intended result. Here again, we have the term narrowly tailored. That's right. So does RCW 46.20 have a narrow state objective as to the licensing of drivers for hire? The answer is no. Can the statute distinguish the right to the issue of a personal automobile in contrast to that of a driver for hire? No. This right to travel is a fundamental right. This is a quote now. Subject to the strict scrutiny test under the United States Constitution. If your judges, your administrative clerks that you are going to do not uphold these kind of quotes that are, or citings, quotes, and sources that are being put in your motions to dismiss, hey, take it on appeal, man. Don't just take it on appeal. If you have literally, I don't know, my situation, this is what I'm going to say. I'm taking it to appeal. If they're not going to honor me anymore, I'm taking it to appeal because I want to get the court record and everything. Because I just need, I got to take it. I got to take it to civil court. I'm taking it to civil court from now. We're going to civil court. We're not playing no more. Okay. I know what's up. Chauffeur on deference is repeal. I'm not playing. You know, y'all can. I'm going to be as polite as possible, as genuine as possible. I'm going to be the coolest cat under the sun with honor, respect, morality, and I'm going to teach every individual I come across. That is, you know, as I can. But I'm not going to stand for rights violations anymore. Neither are you. Okay, this is just. There's no reason for our ignorance to be subject to abuse anymore. We're not ignorant anymore. We're coming through with knowledge, wisdom, and intelligence to know for a fact with everything that we have in the back, and no matter how old it is, that applies, does, and will apply to our situation. Okay, because what it shows is that there's an infringement upon our country, and I don't care what kind of admiralty, maritime, whatever y'all want to say. I am the highest of authority. Any law that is made is still below me because I am the highest of authority. I don't care if it's admiralty, if you want to start talking about all over here. I am the highest of authority. You are the highest of authority. We, the people. This right to travel is a fundamental right subject to the strict scrutiny test under the United States Constitution. 16B, Amjur's 2D Constitutional Law, Section 612. And see also Johnson versus City of Opelousas. That's cool. And then, to be unconstitutional to the restrictions must prevent or limit a person's freedom of movement. To be unconstitutional. For it to be unconstitutional, the restrictions must prevent or limit a person's freedom of movement. 15 Am Juris 2D Commerce Section 1 or 97 and cases cited. So my Hood River, for it to be unconstitutional, I'm walking down the street. Okay, I'm walking the street. Emergency lights have not been initiated against me. Okay, I'm walking. I'm 70 yards away from my vehicle. Hey, get back over here, you guy. Get back over here. Get over here now. We got to talk to you. What do you got to talk to me about? Well, what's going on? I don't want to have a conversation. We need to talk to you. What do you want to talk to me about? We want to talk to you. Okay, I'm reserving all rights. I don't want to talk. Then they come up to me and say, obstruction. Come here. We're putting you in handcuffs. You've literally restricted and prevented my freedom of movement. That's unconstitutional. You can't do that. What was the reason for doing that? What crime did you see me in? Well, it's obstruction because you're not coming down here when I tell you to come down here because I want to talk to you about your car. What do you mean? I don't have to talk to you about my car. I have constitutional rights to remain silent. I already invoked that with your other officer. If he didn't inform you, that's y'all's fault. It's not my fault. What do you mean? What do you mean? What do you mean? We gotta start enforcing it. It's a bigger deal than what we thought. Again, to be unconstitutional, the restrictions must prevent. The restrictions that are trying to be enforced upon you must prevent or try to limit your personal freedom of movement. It's a great one. I love it. Taking into consideration what has been discussed thus far, in order for a statute to have a valid objective, only two plausibilities exists. One, when the personal automobile was purchased, the buyer was then obligated to hire a full-time driver, subject to the license statute, for two reasons. A, certainly one cannot pay himself to drive. B, if the buyer is the operator driver, then he is required by law to obtain a business license and pay taxes to the Department of Revenue. Two, every automobile dealership is, in fact, a de facto motor vehicle distributor, wherein every vehicle purchased is actually a private for-hire vehicle, and the purchaser is subject to the licensing statute. Quote, a partnership or corporation is not entitled to a motor vehicle license as such. Quote, again, a partnership or corporation is not entitled to a motor vehicle license as such. They may register the machine in the corporate or partnership name, but the license must be issued to the person who operates it. Unquote. The law applied to motor vehicle Babbitt, Section 86, citing Emerson, etc., Co. versus Pearson. However, for either of these to be true, the statute would have had to provide substantive notice of the license regulation at the time of purchase. However, for either of these to be true, right? Because there must have been provided notice. The statute would have to provide substantive notice of the license regulation at the time of purchase. Not likely, however, because, as we have seen previously, the legislature has not specifically classified personal automobiles in the personal use thereof. Thank you. You're trying to lump some it all in. The statutes, they haven't classified it whatsoever within the code, within the title. RCW 46.20 is unconstitutionally vague, as overly broad, facially void, and as applied void because it allows the state to indiscriminately interfere with private affairs by using what has now been shown to be driver for hire classification statutes to inflict undue harassment, illegal fines, unlawful imprisonment, and illegal seizure upon a common traveler where no otherwise authority exists, y'all. It's very simple. That's why the notice of liability is so important to deliver and give to those counties, cities, municipalities, corporations in which you travel and operate through. Why? Because it puts you on a high status of within these agencies. It allows these agencies to say, hey, look, this guy really knows, right? He knows what's going on. He has the conversations. He's bringing it forth. You're saying, I don't want to have issues with y'all guys. I really don't. I just wanted to have a conversation. You've seen how I filed my notice of liabilities with the chief. The chief literally in Ridgefield tried to say, oh, man, I don't honor that. I'm hearing you, but I don't believe that way. And I said, well, look, man, let's break it down again. Let me question you again. Let's have a deeper understanding of this. If I'm the public and I'm the highest of authority and you my public servant, right? Right. Okay, cool. Yeah. Okay. Then is it my understanding and comprehension that you understand that I have the right to travel? Dude said yes. I got cops on the record coming and saying, no, yes, you have the right to travel. You are not in commerce. I get it. You're not a sovereign citizen. You are well educated. What does that tell you? It's about the education and knowledge and standing and not waiving your rights. And that's all it boils down to. Whom shall you fear if you allow the great creator to work through you and knowing that everything that you're doing is correct? All you have to do is stand in honor and morality and never waver in who you are. What's wrong with that? There will never be anybody who will say that there's something wrong with that. Ever. They can never say that you're wrong, especially if you're standing in honor and trying to instill positivity, goodness, respect, and integrity. All I hope for in everything that I do, in everything that I do here today, now, and in the future, in every moment that is blessed and bestowed upon me, will be to empower another individual. I will seek nothing more in this life than to empower other individuals with knowledge, with respect, with kindness, with gratitude, with compassion. Why? Because that's what this life is about. Our life is not made to get out here and serve another. Our life is not made to get out here and work for the man and barely spend time with our immediate family. Our life is made to bring upon a, a, a beautiful, thankful expression of gratitude to the great creator. That's what our goal should be. Our goal should be gratitude and thanks for a great creator. That's the goal. That should be the goal of our nature, of our nation, to restore unity of knowing, compassion, drive, upliftment, education, knowledge, wisdom. That's what brings our nation up. That's what brings our nation up. We are going into a new age of enlightenment. You can see it. Look at the education. We're looking at it and how we can apply it clearly right here within these courts and the claims and charges courts, as I am now going to reference them as. All they are claims brought against us or the person. It's really to the point of getting down to understanding love, man. Now we are all one, man. I don't look at nobody as a different from me no more. I look at everybody as family, bro. Like, you my fam, bro. Like, don't you understand? You like my distant cousin. You may not be immediate, bro, but I can go across the world and find someone that looks similar to me. I know people that look similar to my girl in facial structure. What does that mean? We coming from lines and intermixed lines, and those lines change and morph. We've been here, bro. We coming back. We have to unify together. So that's why I say it's important to have these conversations directly with the leaders of these agencies and corporations. So that way we're having a complete understanding. You got to build a contract. You got to build a presentment. You got to build an offer. You got to let them consider that offer. You have to ask for them to file it and give you a copy. Once they do, you have the conversation. You get acceptance. That's how this works. Utilize what you can to get what you can on the record, so that if they violate you later, then you can push forward in your civil litigation, y'all. This is the time for you to do so. We got Operation Wise Dome. We can do anything and everything, y'all. Now, let me address one thing. We got a hater in here, and I'm going to let you speak, brother. I want to always make sure that everyone is freely here to share their opinion. Okay? Always. I don't ever want you to feel like we're out to get nobody or that we don't want. All I want to say is this whole series tells you by law how it goes, man. And you don't have to listen to me. And if you feel different, that's fine. We are now 12 hours in on this document alone, thoroughly going through things. This is just one document. And if you don't see it like we see it, Mr. Richard, it's okay. I still got love for you, and I hope the best for you. And I hope one day you do come to realize the truth of the matter and understand that no one's got power over you. I can understand your concern in relation to possibly, safety on the roads. We're right there with you. We're not saying that there isn't no power over safety and concern on the roads. If someone's out there speeding and going crazy and, being wild and speeding too much and, causing fear to my siblings, which are everybody else on the roads, then yeah, it's a problem. So I'm with you on those aspects. But when it comes to people just getting their car towed and taking financial burdens and extortion being brought just due to the fact that tags or anything like that, inspection ain't up to date, that's wrong. We can't have that. And then we get pissy arguments, people get shot, people get killed. And then when cops go up to the cars, they're always in a certain type of mood because they never know who they're going to encounter. We got to turn around from the enforcement of policies that are really not enforceable against us in the first place. Really, when we break it down to it, we've read the law. It's too vague. It doesn't apply. Right? And we need to get back to allowing our police officers, which I know they want to do, all of our LEO and public service, they want to get back to serving. They want to make sure to do good. And they want to actually get rid of the persons that are actually doing bad out here. They really do. So, Richard, I hope you hear my heart, man. And I love everybody, and I ain't got nothing, no ill will to say anything bad about you, brother. So I just hope you come to realize, like we've realized. I tried to disprove this too, man. It's not like I just came to this and blindly believed it. I came to this trying to disprove it, Richard. I came in it trying to disprove it back in 2016. I couldn't disprove it. It's factual. I've been 2016, several interactions with police. I've only had my car towed one time. I've had several cops verify everything that I've stated. It's all on my shorts, bro. There's so many cops now that are verified. Yes, it's commercial. Yes, they understand that the city's corporation. Yes, they understand that the state's corporation. Yes, they understand that I'm a traveler. Cops are on the record telling me this, dude. So I don't, get why you get mad and argue with me when I have verbatim real life cops telling me that I have the right to travel and I'm not on the roads doing commerce while having traveler plates on my car. How much more blatant can it get than that? Screw you getting the decision. Screw me getting a decision in the court that's going to side on me. They won't do that because they won't even let me argue it beforehand because I file an abatement and they send me letters of dismissal. So what else am I supposed to do, Richard? You tell me. If I'm doing everything I can to possibly get proof out here to get them to approve the right to travel for everybody to see, what else can I do other than go to court, file my documents, and get them to approve it? If I'm doing all of that, and they won't let me even get to the point of arguing it, they just do motions of dismissals. And then if I'm going out in the street and talking to cops about it, and they let me go and don't give me tickets because they actually say, no, you're right, I guess. Yep, yep, you ain't got, or yep, you're out here traveling, you ain't driving. Yep, we checked the VIN. It ain't no more register. It ain't registered on the car. The car ain't registered no more. That's right. That means the security interest on the vehicle through registration that the state may have had is it's lapsed. You have no more co-ownership. I'm not a co-beneficial owner anymore. That's how this works. It's called contract and consent, my good sir. That's how this works. I'm trying to be polite. I want to show love. And I know everything comes through knowledge. I'm be egotistical. I just want to let you know that I have a lot of experience in this, brother. Maybe grab up my book. I got a book I just wrote, Richard. It's called It's called the Last Tread. I'm sure it's in the description. Check it out, brother. It talks about all my experience. I'm really proud of that book. RCW 46.20 is unconstitutionally vague and overly broad, facially void. Yep, we went through that. Common traveler where no other authority exists to remain consistent. RCW 46.55.113 is also void as applied because this statute is an accessory to the fact of illegal enforcement. Quote, or when it uses any classification which it serves to penalize exercise of that right. Attorney General of New York versus Soto and Lopez, as well as Johnson versus City of Opelousas. It is only after careful study of numerous fragmented statutes, as we have been doing clearly, that it is predetermined that the entirety of Title 46 is and only for applicable to commerce upon the public highways, and that all provision clauses thereto can only be enforced to persons who use the highways in and of commercial trade for compensation. The activity licensed by the... I feel like I was lower on this PDF, but maybe not. Y'all tell me if y'all feel like I'm repeating something. I don't want to mess up. I swear I was lower. Let me check something. King County, we presume. Personal drive. There's no such thing as a personal driver's license. Street driving. Where was we at, though? I need to check this first. We were on page, what is this? Come on, give me the page. 136. Let me go down and check real quick. Driving, term commercial, recreational vehicle, law applied to motor vehicles, permit, personal use for giving respect, spoken, autonomy of traffic infraction. Oh, man, I love this document, bro. This document breaks it down for anybody who is doubting anything with its depth. It's amazing. Okay, where was we at? Excuse me, I'm sorry. I'm just wanting to be exact. So, quote, the activity licensed by the state, DMVs, and in connection with which individuals must submit personal information to the DMV. The operation of motor vehicles is itself integrally related to interstate commerce. Do you hear that? Seth Waxman, Solicitor General, the U.S. Department of Justice. The U.S. Department of Justice. How much more plain do I need to make it for anybody, Richard? I'm literally in any court setting that I'm going into myself personally in relation to my right to travel, if they are really violating my rights, I'm literally going to be like, I'm not quite sure, but the U.S. Department of Justice, the Solicitor General, in his brief for the petitioners, especially in Reno versus Condon 98-1464, decided in January 12th on 2000 in the Supreme Court of the United States, that the activity licensed by the state DMVs and in connection with which individuals must submit, personal information to the DMV in the operation of motor vehicles, of course, is itself integrally related to interstate commerce, right? So there must be underlying aspects first to even have an operation of motor vehicles will be classified in that term, such as motor vehicles itself, right? You just be like, it's logic. RCW 46.25 080, license, contents, classifications, endorsements, restrictions, expiration, exchange of information. 1. The commercial driver's license must be marked commercial driver's license or CDL. Licensees must be classified as follows: Class A, Class B, Class C. RCW 46.25 0501, commercial driver's license required, exceptions, restrictions, reciprocity. Drivers of commercial motor vehicles shall obtain a commercial driver's license as required under this chapter. However, this requirement does not apply to any person who is operating a recreational vehicle for non-commercial purposes. Recreational is at my leisure. Recreational is at my leisure, as I so see fit, at my leisure, because I have life, liberty, and the pursuit of happiness in all regards. It is disputed that all driver's licenses are issued under RCW 4620, even those issued to common carriers under RCW 46.25 and RCW 81, as and for the purpose of trade, traffic, and transportation upon the public highways. Below is the implied exclusion rule. Implied exclusion rule. Below is the implied exclusion rule. Richard, man, come on, Richard. I'm gonna just let him keep talking. I'm not gonna ban him. I don't want to ban him. I'm gonna let him go. Notably, it is reasonably ascertainable that the statutes applied to drivers of businesses thereto by implied exclusion. If the statute does not expressly include private travel, then it impliedly excludes it. Quote, 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 for everybody. This is a quote. And it is possible to argue that it is limiting only under the rule of express mention and implied exclusion. In State X Rel, Becker versus Wiley, 16 WN 2D 340133 P 2D 507, this court said with respect to that rule the following: the rule should be applied only if and when it aids in determining legislative intent. This rule should be applied only if and when it aids in determining legislative intent. Okay, do you understand what we do in implied inclusion? Okay, which is rule of express mention. This is another doctrine. So we've already talked about the rule of lenity, right? We've already talked about the rule of lenity, right? We've already talked about the whole act rule, right? Now we are coming into other aspects of the rule of express mention and implied exclusion. Okay, type that up, write it down. Another rule of express mention and implied exclusion. Now, what it's showing is that this is in X Rail, Becker versus Wiley. Okay. All right, buddy. Sorry. You got to get put in timeout, brother. You got to go. Poof. Okay. So, this court said, with respect to that rule, the following: this rule should be applied only if and when it aids in determining legislative intent. So we need to bring forth This rule in relation to legislative intent in conjunction with the whole act rule, or the whole act rule, also in conjunction on a trifecta angle in relation to the rule of lenity, meaning that on the overly broad aspects, right? So, in other words, the principle is to be used only as a means of ascertaining the legislative intent where it is doubtful, and not as a means of defeating the apparent intent of the legislature. Unquote. King County Employees Association et al. Versus State Employees Retirement Board. So another one is, we cannot presume the legislature meant it to be applied to persons. It specifically excluded. City of Seattle versus State. Okay. This is also in 16 AM Jurors to the Constitutional Law, Section 218 at 109, 1998, in Mount Hood Company. Oh, I got a Mount Hood judgment on me. I can use it for really duty. Okay. Versus Constellation Brands Incorporated. And this is all the way, this is just in 2003. So we got something in the past, in the 2000s here. Okay. So there's no such thing as a personal driver license. There's no such personal thing. There's no thing, y'all. There's no thing. I mean, you could make one for yourself if you wanted to, but there's no thing, because you're not a driver and you don't need a license. Are you giving yourself permission? Are you giving yourself permission by obtaining a license to be your own chauffeur, which is a driver? That's literally how this goes. Okay, so as shown previously, the legislature has seen to discuss general licensing schemes referencing RCW 4620, as well as special commercial licenses under RCW 46.25 issued pursuant to RCW 4620. And if this is your first time in the live, I'm glad I'm catching y'all too, man. It's pretty cool. What's up, Julie Uli? What's good, Julie Uli? The F in the stream, redress from tyranny. Yes, we got to redress. Lynn Davidson, what's up, y'all? Hourglass, Sean B, Lynn Davidson in this thing. What's up, y'all? What's up, y'all? What's up, y'all? I also seen who else I see up in this thing. Vicious, I see you. Kinetic still in this thing. I see y'all. Y'all my go-tos, man. Y'all the blood. Y'all the ones that keep it going. You dig? RCW 46.25 issued pursuant to RCW 46.20. But what is not discussed? Neither is it written anywhere in the breadth of Title 46. Is the term personal driver's license. It's not. They can't. They know it's unconstitutional, so they could never put it in. That term is likewise not discussed in the Washington Administrative Code or any other associative policy. However, it does further serve dogmatic the whole act rule, which now undoubtedly has determined the driver license, aka operator license, to be a business license for compensation. Now, not to get lost in the vortex of commercial definitions, the state of Washington has declared by executive directive in the administrative code that driving is in fact driving a motor vehicle in commerce, and that a person is deemed a commercial operator driver. You a driver. I'm not. I'm a traveler. I'm not an employee of the state, right? Because WAC 308-100-005 says employee means an operator of a commercial motor vehicle. That's not me. I'm out here driving so freely you can't stop it. You can't sign me, so you better bag up. Come get those emergency lights up off on me. We traveling, we moving, we traveling, we moving casually, intermittent on occasional drivers. You know what I'm saying? Like, for real. WAC 308-100-0053. Employee means an operator of a commercial motor vehicle, including full-time, regularly employed drivers, casual, intermittent, or occasional drivers, leased drivers, and independent owner-operator contractors, while in the course of operating a commercial motor vehicle, who are either directly employed, they're getting specific by saying directly employed, or by under lease to an employer. Ooh, it's getting real specific out here on what things must be given. WAC 308-100-00510 also says street driving means driving a commercial motor vehicle on a public road where the traffic laws are enforced, consisting of city, street, county road, and freeway driving. And you already know what county road is. We went through that recently. If you don't know, go look in your municipal or county code to look up what county road says. It'll be the most amazing thing you've ever seen in your life. I swear right now. Because it literally says county road definition within your state or within your municipal county or your county code or your municipal code. It says, as a matter open, as a matter of right, open to public vehicular travel. I don't know how much more clear you need to get than that. That's why they leave the statute so vague so that you'll apply and think that you got to apply when you don't got to apply because nobody's ever going to look in their county or ordinance codes in relation to the definition of county road. Who cares? Everybody knows what the county road means. Everybody knows what the county road means, but do you really? Did you find out that right there, a little deep in that county code, especially with the municipalities are the ones bringing the charges against y'all in the first place. So why not go right to their codes? If they're out here violating, if you got police officers that are on the city level giving you tickets, why not have in your glove box the ordinances of that city and county? Why not? Why not have a briefcase with all your documentation with that? Why not have highlighted already your definition of county road? Why not just have it there? Have a conversation if you want to. I'd say go by Eddie Craig's script, but if you want to, do what you want to do. You've seen how I operate. I'm just saying, it's right there. Open as a matter of right for public vehicular travel. You'll find something very similar in your own municipal or county code in your state. I'm telling you, man, it's wild. It's a huge term that we're not looking into and using. Okay, and freeway driving. In fact, the entirety of WAC 308-100 is a mandate to the state of Washington Department of Licensing, directing the issuance of a commercial driver license in no other kind. However, one may escape this tenebrous licensing scheme if an automobile qualifies as a recreational vehicle primarily designed for travel use. Because WAC 308-100-210, the term recreational vehicle shall include vehicles used exclusively for non-commercial purposes, which are primarily designed for travel use. There you go. Recreational vehicle. I'm not. So if you really want to get down to it, if I want to go get a razor and drive that bad boy out on the street, I can, and there ain't nothing you can do about it. Honest to God truth. You want to violate my rights? No wonder why I've been seeing all these people out here in my area with razors just driving on the street with no license. They're like, yeah, man, you're not going to pull that on us. We know what the WAC and the RCW say out here. They ain't going to work. Okay? This is too elusive. As discussed earlier, the term travel is a broad, vague term with contextually express statutory meanings. Notwithstanding, every vehicle run on the highways was designed for travel in one context or another. Caution, be had to recreational use as well, because recreational use has business ramifications. For clarification, the Washington Administrative Code specifically defines the term recreational vehicle at WAC 308-100-210, which policy reads we just read it. Recreational vehicle definition. For the purposes of RCW 46.25.050-1C, the term recreational vehicle shall include vehicles used exclusively for non-commercial purposes, which are 1. Primarily designed for non-commercial, camping, or travel use. Well, there we are. We got a recreational vehicle car. You can't stop me because the definition matches, bruh. You better leave me alone. You don't want to mess with us. We bring in civil suits. You won't like us soon. You'll see me off in a 3-piece suit. I'm gonna sue. You'll be losing your qualified immunity too. So don't stop us, bruh. We warning you. We wanted you. Bro, like what? We not playing with y'all. Get back. Note, the use of the term vehicles have a commercial orientation when spoken in the language of statute. To be sure, there are many businesses that rent out motor homes, and motorcycles and mini cars for tourists to fulfill their recreational muse. Oh, okay. The law applied to motor vehicles, Babbitt, Section 91 at 147, stating, still again, subdivision of the last mentioned class has occurred. Vehicles on four wheels, perhaps, being placed in one group, and those on two wheels in another, or perhaps vehicles drawn by two horses, have been made to pay one rate of license fee, and vehicles drawn by one horse or another. Where then, in principle, is there any distinction when it comes grading or grouping automobiles into subclasses according to their horsepower or the number of passengers they carry? It may be said of either class that the large or heavy vehicle pays a license fee rated on some arbitrary basis. A commercial vehicle pays on a standard established for the class within which it falls, and the pleasure vehicle owner pays his license according to the vehicle which he operates. Dealing on municipal corporation, fourth edition, section 682. Anybody can join any one of the several of these classes as he chooses. So a personal automobile may be used for personal reasons in ways as long as that use is to trade, traffic, and transportation. This was expressed in the case of State versus Sheffield, Chicago versus Gall, Chicago versus Banker, and Howard's Yellow Cab, as it is by intent of the whole act. Look at the whole act rule, my dude. Look at the whole act rule, my dude. You can't go admitting all the stuff that really gives us a clue and then trying to be vague and vague and try to slam the hammer down on us too. Nope, not playing. We're not playing. We invoking. Straight up, we invoking that whole act rule on y'all from now on, in conjunction with the lenity. Yeah, we're not playing with them, y'all. We figuring all this out now. So, giving respect to the rule of exclusion, okay? Giving respect to invoking the rule of exclusion, it was equally stated by the Marr court. While the factual basis of Marr is not precisely adjunct to this discussion, the theoretical resonance is the same. From the language of the statute, one can legally travel as long as he or she does not engage trade or traffic for compensation. One's personal automobile is his personal property, y'all. Just like my personal property, if I want to get on my my daughter's power wheels, bro, I'm gonna get out there and I'm traveling. I don't care the speed in which I go. That is irrelevant, bro. If I want to get out there and power wheel with my daughter, I'm gonna do so. You did. We're gonna in this thing. We're gonna turn on the lights and beep beep with the music, and we're gonna be playing that. Shake it off, shake it off. Whoa, what? What you talking about? We traveling for recreational purposes, bro. Get up out of here. Okay. One's personal automobile is his personal property, the same as the shoes on his feet, and as such, may be used to his personal indulgence, not being in service for hire, y'all. It's all about your intent to use the highways. From the language of the ordinance, this is a quote now. Excuse me. One can legally beg as long as he or she does not do so aggressively. From the language of the ordinance, one can legally beg as long as he or she does not do so aggressively. Spokane versus Marr. Quote, the exemptions provided for in Section 1 of the Motor Vehicle Transportation License Act of 1925, stats 1925, page 833, in favor of those who solely transport their own property or employees for both, and of those who transport no persons or property for hire or compensation. See how far back it goes? It's so far back, y'all. We just had one from 2000. We just had one from 2003, 2002, 2008, 1926. That's why we say that whole act rule, okay, in conjunction with the rule of exclusion, the rule of lenity, we are good to go, y'all. These are all preliminary things that they have to get past before even talking about the actual, were you driving? Where was the probable cause? There's so much beforehand. Okay. So again, the exemptions provided in this section for one of the motor vehicle transportation, the exemptions provided for in Section 1 of the Motor Vehicle Transportation Licensee Act of 1925 it's in favor. The exemptions are in favor of those who solely transport their own property or employees or both, and of those who transport no persons or property for hire or compensation by motor vehicle have been determined in Bacon Service Corporation case as lawful exemptions. I'm exempt. You're exempt. They've already determined it. If someone is going against your exemption as a free living being, okay, what you talking about? The next section is autonomy of traffic infraction, and hopefully this is like one of the last two sections. We are now 2 hours on this one, so that makes this one chapter 11, which is 2 hours. So we're over 12 hours in this course so far, y'all. Okay, and I just want you to know that we're 12 hours. Yeah, we're actually over 12 hours in this course. Let's talk for a moment. Are y'all enjoying this or what? Is this okay for y'all? Are y'all enjoying this? I know I'm long-winded, but this course is very deep. It's like, this is a college course if it's not. Y'all tell me if it's not. This is like a college course, okay? This is like a deep college course in relation to the right to travel. You can't tell me it's not, okay? If they was to implement this document in teaching and having these discussions with students, this document alone, I think it would be a college course. I think it would be a great college course. I mean, it should be, because it clearly allows us to understand, you know, just the depths of everything. This should be a course for every single, this should be part of the law enforcement agencies, right? This should be part of what's getting taught in relation to law enforcement, these depths, because this is, you know, all of our law enforcement are public servants. They need to be well educated on all of our rights, you know, in heavy regards. Not just on policies. I understand, yes, you have to have the policies all in order in relation to the businesses and who you can actually do enforce all of the ORSs and, yes, the crimes. But at the same time, too, you need to know the other aspect of the complete rights that the public has on a deeper aspect. And, you know, I don't know who we're working with on the internal affairs aspect, but maybe we need to work out to internal affairs. Maybe us as public, knowing these deeper aspects, we can, as the public, get involved with internal affairs. You know, try to get involved with public affairs or internal affairs to see if there's any kind of subcommittees that can be developed of the internal affairs directly with your police departments or your sheriff's office as well. Because I think everybody wants accountability and everybody wants to know what's doing the right thing. And yes, you're going to have corrupt ones in there, and we got a sickness in law enforcement itself. We do, but don't you think that we have a duty to repair it? We can't just sit back. You can't just sit back and be like, oh, I can't do nothing about it. You can't just sit here and bitch and complain and make videos all day about it, right? That's why I don't make much videos bitching and complaining about other people's experiences or situations. Oh, this is horrible. Oh, this is what I'm showing my experiences mainly. If I can find somebody else that's directly involved with me, we're going to try and improve their situation and explain what's going on with the travesties that are at hand. And then we're going to try and educate in every aspect that we possibly can to empower people so that we're not wasting our time. So that way everybody can start enforcing it, because that's the only way. Yes, we need to start being the internal affairs. That's so true, y'all. We need to start being the internal affairs. There's no doubt about it. If we can put ourselves into a placement of being the internal affairs on any situation, okay, and really working with internal affairs with that, they're going to, you got to understand, man, like if we're going out about it in the right way, we really are going to start getting a lot of respect. I can already see it when I'm looking over at David over at San Joaquin Valley Transparency. Shout out my boy David. I love you, brother. When he's getting people on, like the city council, he's working with people that's working in the city councils and stuff like that. And the city councils are doing interviews now with David, and they're coming out running for governor. And they're talking about, hey, man, I'm all about the Constitution. I'm all about serving the people. So I'm starting to see that we really are getting a spirit of unity and servitude back into our country. I really think we're getting there, y'all. And I don't care what you feel like on the higher level, as far as like Trump, president, whatever the case may be. My main focus is on community. Okay. It's not me personally. It's not Trump, or Trump is not affecting personally what's going on my community level right now. What's affecting us on any level is the people around us. So we got to start reaching out and talking to those people and having those conversations all across the board to where we're starting to set up that change that we want to see. Because let's say if we are going out and have the conversation with the right people, chiefs, sheriffs, lieutenants, then we're going to council meetings, And if we're having issues on not getting agreements with the conversations that we record and had with our public service, we can go to the council meetings. We can start to bring up and say, hey, look, I had a conversation. You're sending out letters to all the council members that are relevant. And we're starting to say, hey, look, these policies here, I wanted to question some things. I just want to make sure that I confirm these things on the record with y'all. If we're not getting confirmation within the courts, right, there's ways to go about it. There's ways to get things on the record to have deeper conversations. You understand that, right? So it's like people will be like, oh, well, you'll never get something on the record as far as a court case. It's already been established. I don't need to get that per se. If the administrative statutory courts are not going to respect it or honor it, that's a bad problem because the Chevron deference has been repealed, so they must, okay? Then we'll just take it on up to a repeal, okay? If we take it up to a repeal, they're just going to bring it on down, and then everything's going to get cold case. But honestly, if I really don't even want to have to bother in that kind of aspect just to get it on the record, I could just sign UCC 1-308 and not worry about it because there's not a contractual agreement in the first place. So you see how I play it. I'm not going to argue about it because you can't try and come after me, even though you're not going to grant my motion. What are you going to do? Try and enforce some kind of, you're going to come and try and tell me I'm a slave now and you're going to enforce some kind of off my wages? What? Yeah. Try that. Good luck with that. Good luck with that. Good luck. You going to get a debt collector? You going to put it on my credit? Well, we'll see. We'll see how you're going to enforce that because I showed up to court. I did everything necessary to put y'all on notice. So you can't put out no warrant. You can't put out no warrant because I ain't got no contract. So I really understand that's how it goes, y'all. At least on my behalf. Once you file your paperwork special appearance, at least on me, I have never. There has been times now where I have filed my paperwork twice. Filed my paperwork, never showed up for court. Never showed up for court. Filed my abatement and my abatement, yep, and then my memorandum for my abatement. And I may have showed up at the arraignment court. I said I'm not pleading whatsoever. Filed my abatement and filed both of them. Yeah, I did it on both of these. Filed my abatement and I didn't sign anything. And I told them they got to give me a response in those abatements within 30 days. They never gave me a response, and I never replied to them ever since. And they never replied to me either. So they just be dropping off. I've had them in Portland happen to where I didn't even get to file an abatement. I went in on my first arraignment to file it on spot, to get a continuance, just to be, I like to try different scenarios on different aspects, each one to see how things are going to work. And when I went to the Portland, when I didn't even get to, I went to the thing. I said, hey, I'm here to check in. When's this court start? And they're like, oh, well, you're not even put off the docket. They didn't even submit the ticket. Yeah, So we forgot what authority really is. Yes, we did. That's 100% correct as well. I totally agree with that. And it's not authority in being rude. It's not authority in being unbecoming. It's not authority in I'm the baddest in the world, and just bragging on that consistently. That's not my mode. That's never been my mode. I will never go out there and get a camera and put a camera in someone's face and harass with them while they're walking down the street. You see what I'm saying? Like, if I'm going to do anything, I'm going to be trying to, instill some kind of something great and amazing and within each and every one of us, This movement does benefit everybody. And again, the biggest thing too is that, it's just so deep for like people that die or get harmed or their property taken. And it's like, that'd be the last straw. You know what I'm saying? Like, somebody will get their property taken away from them. They ain't got $500 and they ain't got nobody to lean on to get it out. So they literally lose their vehicle in the auction. Over what? A piece of paper? A piece of paper? A fake authority? It's not cool, and everybody can agree that that's not cool, y'all. That's not illogical. That's it. That's not illogical. I think anybody on the higher, I can go to any legislator right now, governor right now, and I can have a conversation. You say, you really think this is beneficial for the state? Do you see it deterring anything? Because it's not. It's kind of like people out here smoking weed, man. You're never going to deter people from smoking weed. People going to smoke weed when they want to smoke weed. You're never going to stop people doing drugs. People going to do what they want to do, bro. You're never going to stop that. You never are going to stop people from doing what they want to do and choosing their personal liberty. You can't stop that. You can only stop what people do to others. You can't stop what they want to do themselves. That will never happen. And if you try to do that, it's just breaking so many liberties right off the jump in the first place. Am I right or wrong? It is peaceful non-compliance, being non-violent, non-belligerent. That's what standing in honor means to me. Standing in honor is non-compliant, peacefully being non-violent whatsoever. We ain't against government, bro. We are good for enforcement of codified common law. Okay? That good old harm. You bring in harm? Yes, we got issues with that. Okay? We don't like that. We don't like it, and we ain't going to stand for it. Period. Regulatory, constitutional regulatory, unconstitutional policy enforcement of codes is not acceptable, especially where you're causing a fee when there's been no harm that's been brought to anybody. And it's extortion, it's blackmail, it's a mob. And y'all know, everybody knows this. Well, since you're talking about hitting the bongs, we're chilling for a little bit now, huh? I ain't got no more coffee, man. Y'all got me out of coffee. Bullies keep you under circumstances to feel you need permission. They do. They try to make it seem as though you need permission. But I've never sought permission for anything in my life, bro. What do I need permission to do? I don't understand. Maybe there will be a point in my life where I get permission to apply for an operating circular agreement with the with the Federal Reserve through a nation, right? But maybe I won't have to, because banking's moving over to digitally, to crypto. So the whole world's changing right now. You dig what I'm saying? Yeah, skirt. We skirt right now, bro. Blaze up, you dig? It is extortion and fraud. And as much as you don't want to be like that, you have to be like that without saying that, right? So you don't want to go in there. If nobody wants, I'm not going to go in there and say, this is extortion and fraud. They're going to be like, bro, you're crazy as hell. But if you take it down the aspect of how we did logically, you can literally see how it's extortion and fraud without having to use those words. It's just articulating it in a fashion which, because you got so many people who are politically correct these days. It's like, if you say extortion and fraud, those are offensive. It's like those are offensive fighting words to them. You know what I'm saying? It's like, these are fighting words. It's like so bad, People just get so offended for just the smallest things these days. And then they want to claim that it's a crime for you to have your opinion by using words. And it's like, bro, don't I have permission to have an opinion and use words as I see fit? Like, it's so weird. It's like, if you use certain words, you're thrown into a certain category. And that to me is just so weird. I get so weirded out on that. Yeah, Richard's out of there. Oh, George came back? George is Richard? It's not that I can't argue against, man. The thing is that there's no point to argue when we've already rebutted them in this same series that we're going through right now. We had to. Like, if you feel differently, you can make your own channel, you know what I'm saying, and do so. But don't come in here and flood the comments in the comments with things that are not true. Because if they were true, I would be like, okay. It's like me. I'll give you an example. So me, sometimes I go over to Chili's channel, the Delete Laws, and I'll get in the live stream, and I'll try to tell the truth on what I think is wrong. And some people may be like, man, you don't know what you're talking about, Cam, get out of here. And it's like, okay, but we go into very deep law, and I've actually put it into practice and wrote a book on it. So it's not like I'm just talking to my ass. Like, I'm trying to get people to understand that you need to stop waiving your rights as far as giving up your information and submitting to someone. You don't have to submit to anybody. Every time you do that, you are submitting. Are you subject to somebody else? Are you a slave? Are you a subject to someone else? Giving up your information is submitting to someone else, y'all. And I don't think that's okay, because in submission, there's fear. That's what bothers me. In submission, giving your information up, there lies fear. There lies fear and intimidation. And that's not okay to me. I don't think people should just be getting in fear for no reason. There should never be that. And that's where we are in relation to those that we have put into a position and pay for take care of us. And I understand that job is hard. Don't get me wrong, bro. I wouldn't want to be that person that has to be a police officer. I never would. I would never want to. Yeah, I understand how hard that job is, bro. But at the same time, the people's coming together to where we're starting to understand that you don't have to do everything that you thought you had to do as far as enforcement is concerned. And actually, a lot of things that you are doing are unconstitutional. So let's get back to the basics and start doing what we need to do to pay attention to what's more important. And then by education, we started uplifting everybody. Because I really do, I see channels out here, all they got to do is call LEOs pigs, and all of them are scumbags. Bro, there's a lot of bad ones out here. Just like there's a lot of bad people in the church. There's a lot of bad people within the workplace. There's a lot of horrible bosses, bro. There's a lot of bad people in the financial sector. There's bad people in everything, okay? But that doesn't mean that every cop is bad. And yes, we have a sickness in you know, our culture, but that doesn't mean we can't improve it and make it better. And what does that mean? That means we have a duty. So instead of saying every cop is bad and they're all pigs, how about we figure out how to empower a better culture within our LEO system so that they can say, yo, we stand for rights. We done with this. I think it comes through traffic law reform. And I think Nevada may be seeing that with their decriminalization of all traffic law. So it's a start, and that's where we're at. And I'm sticking to my goals, yo. I'm not playing. We need to get this traffic law reform petition up to 1,000 signatures, y'all. It's almost at 500. I think we're at like 580 something now. I haven't checked it this morning. We need it to 1,000. I need everybody to sign this bad boy. Traffic law reform petitions at change.org. I'm gonna sign off on this one, y'all. And then y'all remember tonight we got Operation Wise Dome. It's popping off at 6 p.m. Pacific Standard Time. We getting into helping everybody, getting into everybody. Y'all show up. That's free. The Zoom or the link is in the description of this video, and then the Zoom link is there. Okay, so you can't miss it. It's pretty easy. But I love y'all, and I want y'all to remember, yo, whoever's been here with me this whole one, y'all are a foundation to something great. I want you to know that. Your wisdom and your education is going to spread because I know you're going to talk to people. You're so interested in this. You can't stop because it's showing you the power that you got to be free and what you can give to other people to be free. It's not just about you. And you know that. And you know that's not what it is with me. It allows us to do more research and study because you're not just taking what I say. This is a collective thing. We all got our opinions to put into the pot to continuously grow and stand on what we want our children to have, what we want to have ourselves before we leave. Like, man, what? I want everybody to be free. If you harm it, your ass grass, bruh. Believe that. We're not finna play with that. You cause some harm, your ass grass, bruh. But if you're living free, you're good to me. Okay. And I just want you to remember always, whether you're new or old on this channel, I am you and we are us, all a part of the great I am. And all power is inherent in you and me, which are we, the people. It has been recognized by the next person that is so-called coming in to lead the country that we, the people, govern everything. Regardless of how you feel about somebody, everybody knows we govern this. You just got to act on it. So act on it. I love you. We'll see you later. Bye. Peace. Where's the in stream? I gotta go pee so bad, bro. Oh my God, I've been holding it forever.